May, but I stand corrected on that, of 2025.
I'm sure just the question about the commencement may have been misplaced. Maybe it should have been about the matter that as soon as it started, I think it's around May. I mean, there are council that had been appointed to render opinions and so forth. So from the NPA side, it had been gathering ongoing information about the matter, and the same you want to suggest, because there is correspondence that was from Advocate Chauke, you want to suggest that the team may have been also involved as early as then, or are you saying with certainty that the Chauke's team was involved as early as then, around May?
I'm not saying anything with certainty. I'm saying that they should answer that question. I cannot answer the question for them. I don't know when they were involved. I can draw inferences, and often inferences drawn from sketchy facts. But you're asking me for knowledge, and I can't give you that knowledge.
Okay, thanks. And just one more question. Is it correct that thus far, evidence that has been led by the Chauke team is, or rather, let me rephrase it. The documents that have been relied upon by the Chauke team on evidence that has been led thus far, is it correct that those documents are from the NPA?
I think the answer to that, the answer to that is generally yes, but there are instances where documents were presented that do not appear to have emanated from the NPA. I would refer in the first instance to some documents that were presented to Advocate Patoi, which related to correspondence that had been sent to Advocate Chauke from, if I recall correctly, from Greece, Mr. Danikas. And then there were also videos that were referred to, which we have raised in the papers, of which we were entirely unaware.
Yeah, I'm just talking about the source as to whether that information, even including the video recordings that you are talking about, would have been sourced from the Office of the National Prosecution Authority. Is that correct?
I'm saying that most of it that they've relied upon comes from the NPA, yes. But there's some information that doesn't appear to emanate from within the NPA.
Okay, that's fine. Thank you.
Thank you, Madam Chair. I'm at your mercy, Madam Chair.
Yes, I just want to clarify one point, Council. Fundamentally, the crux of the MPA case is that his case has not been properly being advanced in these proceedings. And that's your paragraph 55 of the founding papers. And that is supported by the propositions, which are even conjectural, in paragraph 56, where the NPA says, whilst the NPA understands the independent and neutral role played by the evidence leaders, it is concerned that in discharging this role, there may be an disagreement between the NPA and the evidence leaders on which witnesses to call and what evidence to present. That's speculative. The next part, which is also speculative, is that the evidence leaders may also decide not to pose certain questions to witnesses called. So this is in support of your case, that the NPA case is not properly advanced in this proceedings. So the NPA is concerned that the evidence leaders may not agree on which witnesses to call, and they may not agree on what questions.
So what we're saying is that if you've got, at the moment, you've got questions being posed and attacks being mounted against both the NPA and officials of the NPA. It was suggested during the cross-examination of Advocate Batoy that action should be taken against the various people involved as the prosecutors in the Kwazi and Lawville matter, as the prosecutors in that case. Action should be taken against the DPP, the current DPP of KwaZulu-Natal. So what we submitting is that the nature of the attacks, because the proceedings are inquisitorial, and within the inquisitorial process, there's a right, no doubt, to cross-examine. But what we say...
No, I'm not concerned to understand why the proceedings have assumed an adversarial nature.
Well, those are the propositions.
Very briefly.
Those are the propositions, is that there have been attacks on the NPA. The NPA's alleged suppression of information or evidence. The NPA's withholding of certain information and documentation. And it's all encapsulated in those broad propositions.
And if there's a criticism by a party during the proceedings, that proposition or that criticism will be attributed to the panel, as if the panel has made a findings or decision or recommendation about what was then presented by a party, or even if there's a criticism from the media.
So I'm not following the question, Madam Chair.
My question is, if there is a criticism by a party, in this case, Advocate Chauke's team, if they criticize the manner in which NPA dealt with the matter, should that criticism then be attributed to the panel or the inquiry as a whole, as if any findings is made?
No, that's not the proposition per se. Insofar as the panel is concerned, the panel obviously receives information, and the panel allows questions or prevents questions from being asked. And the panel, of course, always has not only a right but a duty to prevent questions from being asked or from allowing questions to be asked. That's the proposition is not that is to be attributed to the panel. The panel hasn't made findings yet.
But if a party makes a proposition that information is suppressed by the NPA can counter that by presenting information to the evidence leaders. Not so.
Undoubtedly that is so, but the issue is over here, apart from the questions that I've already raised.
I think the answer is it is not so. Because you'll have an opportunity. You people are here to present evidence, one side saying this, the other side saying the other. Then the panel will eventually makes a ruling or makes a recommendation. It cannot be that during the hearing of evidence, NPA then says, based on the proposition made by the other side, we are being denied an opportunity. When the NPA is here, it can participate through the evidence leaders as it has done. Now it relies on conjecture. You are speculating and say witnesses may not be called, our questions in relation to cross-examination may not be posed. On what basis should we accept the case that we made based on speculation?
On the basis, Madam Chair, that Advocate Norco testifies for 3 days, Advocate Mahema testifies for 5 days, and that he's cross-examined for less than half an hour, half a day, and likewise with Advocate Norco. So what we're saying is that our intention is simply not to criticize the evidence.
Counsel, you were here, you're seated here when Advocate Norco testified. Your junior was sitting here throughout. Nobody stopped you from posing questions through the evidence leaders, correct?
And we're not saying that anyone stopped us. We had given questions to Advocate Huwe. We do not demand. That's part of the complaint. We do not demand explanations as we would be if they were representing us. But our intention is not to criticize the evidence leaders. We simply saying that we want to be afforded an opportunity to be able to present the case which the NPA believes is the case.
Now that Advocate Norco has come and gone, and you are seated here throughout, you were given an opportunity through the evidence leaders to pose questions on her, what is to happen? Do you want her to be recalled?
We may well ask for her to be recalled in order to present to cross-examine her on certain questions that she had posed. Certain evidence that she had presented.
Well, you have to convince us that you are entitled to that request, because in the first place, wait a minute, in the first place, Counsel, you were seated here throughout with your junior. You had an opportunity to request us, as you often request us. We have never denied you that opportunity to ask Advocate Norco's questions. So you have to give us a clear basis why you will be entitled to have her recalled. And in any event, she may not even be available in the next few months.
Madam Chair, that application is presently not before you, an application to recall Advocate Norco.
Yes, thank you. I know that you have gone far beyond your time, Counsel. I think because your answers are long, and we thought that you stick to the hour.
Madam Chair, your attention has been drawn.
Maybe I'm just talking to you only. It should be a private talk between me and you. I'm saying your time is long gone, Counsel, probably because your answers are long. My sister would like to ask you the questions. I'll request you also to be brief.
Yes, it's just one thing. Thank you. Advocate Hali, I noticed that throughout the application, the founding affidavit, there is no information on which we are informed that the evidence leaders have failed to present evidence or ask questions in respect of specific witnesses. The only time that we get some sense of this apparent failure by the evidence leaders is in reply. In the founding affidavit, there are no specifics at all. The specific just comes up at the time of reply when trying to address the concerns raised by the respondents in the application. And the respondents in particular, we know the active respondent is Advocate Chauke. Do you have any comment to that? I find that response in, I think it's paragraph 24, paragraph what? I have to check. Paragraph 24 and 35. Let me check and not try to be...
So, insofar as insofar as Advocate Norco is concerned, we've raised the factual issue. We've said that this is not a mere theoretical concern, but here's a factual basis to what we are saying. Insofar as putting the specifics about what has been presented to the evidence leaders, that we have not we've not set out in the founding affidavit, and we have not given specific or substantial details in the replying affidavit.
Yeah, what I'm bringing to your attention is that the mention of Advocate Nuku only crops up in the replying affidavit. I think it's at paragraph 34 or so. Let me just check. Paragraph 34, that's when we hear for the first time about Advocate Nuku as an example of witnesses in respect of whom the evidence leaders may be failed to heed the propositions or recommendations or advices.
So if you consider paragraph 51 to 53, in fact to 54 of the founding affidavit, we deal with Advocate Norco. We say over here, we talk about the fact that she had herself been the subject of an inquiry into her own fitness to hold office in relation to her conduct in respect of various matters, including aspects of one of the very matters that is presently before this inquiry. We have identified, if you recall, with reference to Advocate Norco's her own affidavit and the memorandum, the communique that she sent to various people within the NPA, she herself identifies what those different matters are.
53, 54, and 55, and then we'll deal with it when we
Thank you, Madam.
deal with the
Madam
application.
Ramaphosa.
Thank you.
So when it comes to the question, if I might, when it comes to the question, and I'm not going to go through the paragraphs now, the question of where does the right of the NPA to participate in these proceedings emanate from? If I can just ask the tribunal, I'm not going to take them through the passages. Thank you, Madam Chair.
Your time is up. You can take us to just the paragraphs and
That-
not
That-
be the point.
Correct. I would ask the panel to consider the case of the Democratic Alliance versus the President of the Republic of South Africa. And if you would, in the typed bundle that we've now got before this panel, if you consider pages 181 and 183 at paragraphs 25 to 26, 186 at paragraphs 30 to 32, paragraph 34, 36 to 37, and 39, and then in relation to the nature of the NPA's role, if you could consider the provisions of section 179 sub 4.
Before you go there, the DA case that you've referred us to, I really struggle to understand its relevance. The law is tried in that regard, but I struggle to understand the relevance of those passages to this inquiry. Because the DA was a party. They were dealing with parties there. NPA is not a party in the sense of any relief being sought against it.
So what the case deals with is the standard to be applied by the President when deciding whether someone is a fit and proper person. In that case, it was an applicant.
We understand the case. It is this rights issue that you seek to address that I'm struggling with.
So where we locate the rights is in the first instance under the principles of natural justice, in the second instance under the principles of the rule of law, in section 1C of the Constitution, in the third instance under the provisions of the actual NPA Act itself.
Yes, we have seen that, Council, in your submissions. But I still battle where section 179 comes in. Where does the NPA give you the right?
The DA case.
How? Yes. And how does the DA versus the President assist the NPA?
The DA versus the President, I've already sketched what its context is. The importance of it is that the President, in that instance, it requires that the President should act rationally when making an appointment. So whilst the President has a broad discretion, the President's discretion is not limitless. The President is always subject to the obligation, whether it's executive power or otherwise. It's always subject to the law.
But how does that apply here?
Is that case stipulates that in exercising his discretion, the President must have regard to all relevant information and must also, and in relation to this we say, when one looks at our location to the issues within this case, that means it must afford the parties in this case, the NPA in this case, an opportunity to be heard. Otherwise, the President would be acting irrationally.
Yes, thank you.
If I could just one further case, Madam Chair, because...
Well, we have noted all the cases that you have referred to. We have read your submissions. We have read the papers. You can be rest assured.
Thank you, Madam Chair.
We have looked at the case law and the authorities you have referred us to, including foreign jurisprudence. You can be rest assured we read the papers.
I appreciate that, Madam Chair.
Do you still persist with the request to amend the rules?
We would ask that you ought to amend the rules, Madam Chair. Understand where you're...
No, I beg your pardon. You can't say you ought to. Maybe we can make a submission.
Yes, we do persist with that. The extent to which you...
That's fine. If you still persist with that, we'll look at the papers.
Thank you, Madam Chair.
Yes, thank you. Advocate Goitobi.
Thank you, Madam Chair.
I apologize sincerely that we have taken a bit long. We cannot just blame Advocate Halley. We engaged him, and it took a little bit more time. We have read your papers.
Yes.
But you can have your 10 minutes.
Yes.
Uninterrupted.
Thank you.
If a need arises, we'll ask questions.
Thank you, Madam Chair. There are 5 reasons why you should dismiss this application. Reason number 1 is that there is no factual basis for it. Reason number 2 is that there is no legal basis for it. Reason number 3 is that if you grant it, it will produce prejudicial consequences which cannot be remedied. Reason number 4 is that the application is based on hearsay which has not been corroborated. Reason number 5 is that the application is an abuse. If I can start with the first reason, which is that there is no factual basis for it. The application is full of speculation. It is not grounded on any facts. In fact, Madam Chair, the application is grounded on a falsehood. The falsehood is that the NPA has no rights to cross-examination, and only Mr. Chauke has the right to cross-examination. The truth is that the NPA has the right to cross-examine. The truth is that the NPA has the right to bring any witness. The truth is that the NPA has the right to bring any documentation. The issue is that it must do it through the evidence leaders. It has no right to do it other than through the evidence leaders. And that is because the President has assigned the responsibility to draft the rules on the chairperson. And the chairperson has not only correctly but rationally and reasonably elected that the exercise of cross-examination should be done through the evidence leaders. The NPA says that the evidence leaders are overwhelmed by the sheer volume of paper. We too are overwhelmed by the sheer volume of paper. But that does not mean we will violate our obligations to Mr. Chauke to represent him properly. So if it means we must work over the weekends, we do that. If it means we must consult extra witnesses, we do that. Similarly, Madam Chair, you too are overwhelmed with paper and the volume of the documentation. But you too are also working tirelessly at night. You are not asking for someone else to perform your role as the panel. We're not asking for someone else to perform our role. I have a lot of respect for my colleagues who are leading the evidence, not only as colleagues. I believe they too are working very hard to make sure that the case is presented fairly and objectively. So the claim that they are overwhelmed is not supported by any evidence whatsoever. When you actually examine closely the founding affidavit, you find only one explanation behind this veil of being overwhelmed. It is that some information was given to the evidence leaders about Advocate Noko, and that information appears not to have been used by the evidence leaders. But that cannot be used as a basis to draw radical conclusions that the evidence leaders are overwhelmed by the sheer volume of paper. When you actually think further about Advocate Noko was called at the instance of the panel. So in that sense, she is a unique witness. She was called at the instance of the panel, not at our instance, not at the instance of the evidence leaders either. She became a panel witness. It is alleged that she was not questioned about her knowledge of poker. That may be so, but it is irrelevant because whether she is correct or incorrect about poker is irrelevant. She is a factual witness. What is important is that the panel itself must get poker correct, and we will argue that at a later stage. It's not necessary to resolve it now. If you look at the third basis for this claim, which is Advocate Harley has been involved in the matter for more than 6 years. I wish I were him, but I'm not. I've only been involved in the matter for the last 6 months. But I'm not making excuses. The same with my juniors. They have been involved in the matter for the last 6 months. One of my juniors only for the last 2 months. But we tolerate no excuses. The fact of the matter is we've accepted the brief and we must do our job. So we have had the same amount of time that everybody else other than Advocate Harley has been involved in. When you actually think deeper, Madam Chair, about what Advocate Harley is saying, He is basically saying he is the only one in this room who can run this case. Not you as the panel, not us, not the evidence leaders. He is the only one. Even his junior cannot do this case. It can only be done by Advocate Harley. Now, he says that in collaboration with Advocate Karen van Rensburg, because she is the deponent to the affidavit of the NPA. And when you think, where does he get this authority from? He says it's because he was at the State Capture Commission. He says it's because he has been prosecuting the individual prosecutors inside the NPA. We had not wanted to raise this, but for a long, long time, Mr. Chauke has told me that Mr. Harley is probably conflicted in this matter and should probably be recused. And we've refused to carry out that instruction. And today we have been told that, well, I have been in the case for the last 6 years. Often it happens that an advocate who has been involved in the case for a long period of time has a particular pattern of thought that they want to stick with, no matter the forum and no matter the countervailing evidence. So I wonder, without attributing anything, whether that is not in fact what has happened. Because the NPA is not asking for any other advocate in the whole of the Johannesburg bar. They're asking only for one person. Because on the logic of their argument, only one person can do this case. Now, you cannot make a ruling with such profound consequences for your inquiry for Mr. Chauke on the basis of the convenience of one man. And then when you look at, you ask Mr. Harley, one of the panelists asks, he says he is basing his claims on common human experience. Quite frankly, I have not seen any fault with the way the evidence leaders have run the case. Mr. Harley says it is not fair that a witness is led for 3 days and is cross-examined for half a day. Why not? Why not? There's nothing unfair in a witness being led for 3 days and cross-examined for half a day. And we must remember why we are here. It is simply because at a certain point in time, we reached the conclusion as Mr. Chauke's team that the inquiry must move forward. And if it means we must bring our witnesses before they close their case, so be it. But the inquiry must move forward. We are now being criticized for that decision. What should we have done? Walk away? Play obstructionism? We didn't have that option. We didn't think we had that option. Because at the end of the day, Mr. Chauke believes he's innocent. And he thinks he must call the witnesses to prove his innocence. And he thinks he must do so regardless of what is going on between the NPA and the evidence leaders. So what he is trying to do, in summary, is to try and assist not only the panel, but the president to show that Advocate Batoyi lied about him. That is what he is trying to do. So we say, in the first instance, there is just no legal base, no factual basis for the application. I want to come to the next point. We also say there is no legal basis for the application. Our learned friends have failed to identify a single legal provision that entitles them to run the case as if they were a parallel evidence leader. This is very telling when you listen to Mr. Harley. He says, by the very nature of the NPA, they have the right. But you cannot source a right from the very nature of the NPA. You have to source the right in law. So what do? They scramble around. PAJA is inapplicable because that's the only source of the right to procedural fairness in this country. We've shown in our heads of argument that it is inapplicable. Then they look at another source, the rule of law, Section 1C of the Constitution. But it is such a nebulous reference that you can reject it without more. Then they say, look at the NPA Act. Section 12(6) doesn't give them the right to run a parallel prosecution. Then they complain that the president would not have enough evidence and therefore is likely to act irrationally if they do not have the right to play a parallel prosecution. But there's no basis for that, because every piece of evidence they wish to present can be presented. They claim to have given the evidence leaders some information about Advocate Noko. Madam Chair, at Chambers, I said, right as soon as this was mentioned, I said, we will not tolerate any more ambushes like they were doing with Advocate Batohi. If they have information that is relevant to the witness, the information must be disclosed upfront, to us as well. Why? So that when we consult with the witness, we can put the adverse information to them, which is what we've tried to do with every witness. We find information that is good for the witness, we find information that is bad for the witness. In consultation, we confront the witness with both statements. Today, you will be hearing from Ms. Shamila Williams. There is some material there, because she was from IPID, which is critical of her. We've put it to her, and we've said, go to the panel, explain yourself. So none of the grounds that have been cited by the NPA as constituting a legal foundation for the case have any validity whatsoever. The fact that Advocate Batohi has been criticized...
Pardon, Counsel, I think your 10 minutes has lapsed almost.
Yes, I'm in your hands.
Yes, but let me just verify and clarify the point relating to the evidence the President having no evidence in relation to the rationality principle. How does it arise here?
It's irrelevant, Madam Chair. It doesn't arise at all. I mean, the best way to think about the argument is that if the NPA does not question witnesses, the President will not have enough information at the time that he makes a decision as to whether or not Advocate Chauke is fit or not fit to hold office. But that's 3 stages away from where we are today.
Had the President been given the information that was presented to this inquiry at the outset, would you say the President may probably not have established this inquiry? I mean, when you have all these dockets that are now presented before us, given the real issue here, I'm not prejudging the matter, but I'm simply saying, given the fact that the President was given the files that were given to us, which were legal opinions, including the legal opinion of Advocate Halley, in those files, none of the 23 dockets were included, not even a summary of those dockets.
Yes.
What do you make of that?
Well, certainly the President would have taken that into account, and I think it would have been a weighty consideration about whether there is a basis to establish an inquiry of this sort. And it's difficult to say he would not have established the inquiry, because he was being urged upon to do so. But he certainly is a factor that would have been weighty in his consideration of the matter. There is also another...
In the letter by the President responding to Advocate Chauke's response, I don't have the letter right now, but the President suggested that it will be proper to, I'm paraphrasing, it will be proper there to investigate the allegations. Now, if all this information was presented to the President, the President might have considered appointing other people to lead the evidence, most probably. Maybe even the NPA, maybe even Advocate Halley, we don't know.
Yes. Madam Chair, there is nothing wrong with our colleagues. You know, honestly, there is nothing wrong with Mr. Mutlamunyane. There's nothing wrong with Mr. Mutweni. It is an insult that we are sitting here debating whether 4 black lawyers are better than 2 lawyers that have been appointed by the NPA. It is a grave insult that we are still defending our reputation and our standing as black advocates in this country against people like Karen van Rensburg. How Advocate Motibi ended up supporting this application is beyond me. If the evidence leaders don't wish to defend themselves, we shall do it on their behalf.
You may deal with the next point you raised.
Thank you, Madam Chair. The third argument is that,
The prejudice to
yes, there will
Advocate
be
Chauke.
prejudicial consequences. Now, Madam Chair, we have completed, well, perhaps let me start with Advocate Batoyi. Advocate Batoyi elected to walk out and abscond. After absconding, she then made demands that she will only return after she has received legal advice. But that is her choice. We will deal with the consequences of that in closing argument. The three witnesses that have come afterwards, Advocate Mayema, Advocate Noko, and Mr. Mangena, have testified and gone. The prejudice is you cannot have a category of witnesses whose evidence has been presented according to one regime and a different category of witnesses whose evidence will be presented on a different regime. That creates an untenable inconsistency in the procedural framework of the inquiry. Number two, Advocate Chauke cannot be subjected to 2 rounds of cross-examination. He will open himself to be cross-examined by Advocate Mohlamunyane, and if Advocate Mohlamunyane wishes his junior to cross-examine, he will open himself to that. What he will not tolerate is double cross-examination. No other witness who has come here has been subjected to double cross-examination. Every witness has been subjected to a single round of cross-examination. That cannot change in relation to Advocate Chauke. Number 3, the inevitable outcome of the NPA's application is to prolong these proceedings. Advocate Chauke is entitled to a speedy resolution of his disciplinary inquiry. If he is guilty, he must be found guilty and fired, and then he must decide what to do with his life thereafter. But if he is innocent, he needs to go back to work and resume his career. What is intolerable is to prolong a decision about his guilt or innocence. Unfortunately, it's inevitable that there will be additional time that has been spent if you granted the application by the NPA. On the other hand, if you say to the NPA, you know, Madam Chair, I think I was saying this to my junior, Mr. Ramukhal, when we began, you repeatedly used the phrase hand in glove, that the NPA and the evidence leaders should work like a hand and glove. Now, one of them didn't listen to that. And it's clear that it's the NPA that didn't listen to that.
No, the NPA conceded, it accepted, if you look at the transcript,
Yes.
that they will work together with the evidence leaders
Yes. Thank you, Madam Chair.
in that fashion,
Thank you,
as we proposed to them.
Thank you, Madam Chair. They just need to be reminded today that they must continue working hand in glove. We just cannot tolerate the scenario in which the evidence leaders are constantly being undermined by Advocate van Rensburg. So we say with respect, there will be prejudicial consequences to Mr. Chauke. There will also be prejudicial consequences to the panel itself, because you just cannot meet your deadline. We don't want a scenario in which Mr. Chauke returns to work on a technicality because the time has ended. Because the cloud will continue hanging over his head that he was once accused and he was never exonerated. So we want him to be exonerated. So we want to finish the hearing within the time stipulated by the president. And then there is this.
Well, Advocate highly raises the problems, yet the commencement of his argument, he refers to the problems. Two of those problems relates to the statutory provisions.
Yes.
What do you make of that?
But the statutory provisions is a legislative impediment. No one can do anything about it. The same as the maximum period of this inquiry. It's a presidential prerogative, and no one can do anything about that. The bottom line is that all of us must work within the constraints of the statute and the constraints of the presidential decision. But we've got to do our best. And then there is the point, which is the fourth point on the prejudice. The NPA cannot identify a single witness that it gave to Advocate Mohlamunyane, and Advocate Mohlamunyane said, no, I'm not calling that witness. They cannot identify one. They complain about Advocate Noko. Advocate Noko never refused to testify. She gave two options. One, I will come if I'm called by Advocate Chauke. Two, I will come if I'm called by the panel. She came as called by the panel. The fourth point is that the application is based on hearsay. The application makes sweeping generalizations about what has happened in this inquiry. They come from a witness, Advocate van Rensburg, who came here twice, 2 times. I don't know how many days we've sat, but I wouldn't be surprised if we've sat for longer than 70 days.
A deponent.
Yes, the deponent, yes. Advocate van Rensburg is the deponent in the NPA's application. She has been here only twice. There is no confirmatory affidavit, even from Mr. Sebelemetsa. I would have thought that Mr. Sebelemetsa has not been around maybe only 5 times. But for the bulk of the time he has been here, he is not confirming what is being said there. And he is the attorney that is briefing all of us. Well, it's not briefing us, but he's paying us when he does. But the fact of the matter is that there is no confirmatory affidavit from anyone who has actually witnessed what has happened. I understand Mr. Harley cannot depose with the affidavit because of the constraints of having to argue the case, but surely the attorney can depose to an affidavit supporting it. What is intolerable is to have a witness who speculates about things that have happened in this inquiry when they have only been here twice. And you should therefore take it with a pinch of salt, what she says. Then the last point is that this application is actually an abuse. We start off with Advocate Batoyi just walking out of the inquiry and then coming on conditions. Having started the inquiry, there is a pattern of abusive behavior. Then we think about deeply, what are they saying about Advocate Noko? They say they want to attack her credibility because she had been suspended at the time. They say that she doesn't understand poker. What does that have to do with the fitness of Advocate Chauke, which is the center of this inquiry? And then you have Advocate Motibi, who it is said, Madam Chair, I wish to quote what is being said in the founding affidavit. In paragraph 6 of the founding affidavit, Advocate Motibi was appointed as the NDPP with effect from 1 February 2026. In the ordinary course of events, he would depose to this affidavit. Advocate Motibi does not, however, have sufficient knowledge of the facts relevant to this matter. Advocate Motibi has been briefed on the matter, and meetings will continue to be arranged with him to appraise him of the developments in the matter to enable him to have a complete understanding of the matter. He is, however, persuaded that this application should be brought immediately. But they concede that he does not have knowledge of the case. But despite not having knowledge of the case, he has authorized the institution of this application. This is the height of irrational behavior. We complain about this in the answering affidavit. You know what they say in the replying affidavit? They say, no. The decision to bring this application was taken by Advocate Batoi. So where we've got Advocate Motibi, who is no more than a rubber stamp for decisions that have been taken by an NDPP with a personal gripe. Now, this is an example of the abuse that we are subjected to by the NPA. It is also abusive in another sense, Madam Chair. You have repeatedly warned us. You know, I say to my juniors all the time, just listen to the warnings of the panel and comply so that we can all work together. You've repeatedly warned us that we are running out of time. Today we have a witness waiting in East London who wants to testify. We have another witness we've arranged for Wednesday and another witness potentially for Friday. The knock-on effect of this side skirmish is that the two witnesses that are waiting may be knocked on for next week. Yet on Monday next week, we have Mr. Danikas, who's waiting for us in Greece. Why? Because we're trying to put as much evidence as we can collect before the panel so that, in our view, respectfully, you can exonerate Mr. Chauke. The abuse comes in the fact that it's eating upon valuable time of the inquiry, particularly bearing in mind that it has been brought too late. On the case of Ketumano, we've done half of the case. If you think of the witnesses we've called someone from the NPA and we've called someone who was a forensic investigator. But today we're calling someone from IPIT and we still have to call someone from DPCI to complete the picture, and then two factual witnesses to complete the picture. So 50% of the Ketumano case witnesses have been called. But the remaining 50% are going to be dealt with on different rules altogether. That too would be abusive. And that is why, Madam Chair, with the greatest of respect, we say the application is brought on a falsehood. It should not be tolerated. It's ultimately an insult to the capacity and the ability of the evidence leaders. It doesn't matter how much you can try and change the character of it and say it's because they're overwhelmed. We too are overwhelmed, but we're doing our job. So you have to accept the premise, the insulting premise, that 4 black advocates cannot handle this case. Surely in 2026, we should not be living through this. So we ask with respect, Madam Chair, that you should dismiss this application because it's a contemptuous application.
Before you proceed, and I'd like Advocate Hali to deal with that in reply. A suggestion is made that when the panel allowed Advocate Chauke to lead his witnesses, it did so at the disadvantage of the evidence leaders and the NPA. I'm paraphrasing what they are saying in their papers. And they seek to suggest that that in itself makes the process adversarial.
Madam Chair, you can only make that claim if you've not been sitting with us here. If you have been sitting with us, you would have known that right at the beginning of February, there was a problem. There was the problem that the evidence leaders couldn't secure their witnesses timeously. We could have tried to exploit that problem, but our view was not to exploit it, but to assist the process, to say our witnesses are ready, they should be called. That could not be construed to disadvantage the NPA or disadvantage the evidence leaders. In fact, Madam Chair, if you recall correctly, when we debated this issue at the morning meeting, Advocate Skosana supported it. He said, actually, that takes the pressure off us because you can run your case. We, in fact, drew up an agreement. Half of that agreement was struck out by the panel, which I'm still aggrieved by. But the fact of the matter is that it was an agreed decision. With the NPA being in the room, Advocate Hali was with us in the room when we agreed that the way forward will be this. We even had a clause that said, if by the time we finish, they have witnesses they want to call, they must apply to the panel and then they can call them. The panel scratched that out, which means they now have an automatic right to call the witnesses. But we would have lost by now, Madam Chair. We've spent the whole month doing crucial evidence. We would have lost the whole month without evidence, because what they said that the next witness would be Major General Boysen, but he is only available at the end of February, and his statement will be available at the end of February. I don't want to speak about the fact that we have not received that statement even now, which would have meant that we have a whole month that's wasted. So to now claim afterwards that it has come at their prejudice ignores the facts, but quite frankly is opportunistic. And so we say you cannot base your decision on something that is not factual.
And in any event, in litigation, if I may use the example, if a party is not ready and the case is being dragged, the opponent can set the matter down.
Yes.
A defendant can proceed and set the matter down and proceed
Yes.
with the matter.
Yes. And ask for a dismissal,
And ask for a dismissal.
which we haven't done.
In this
Yes.
event, in this case, the panel sought to facilitate finality so that once the evidence leading team is busy with their witnesses, then the proceeding must continue
Yes.
because time is very limited.
Yes.
If we are to wait for another, say, 2 months, where will that take us?
Yes.
We have only a very limited time.
Yes.
And remember, it was proposed last year that this inquiry should start in January or February.
Yes.
I'm not even sure whether the parties were aware of the provisions of the NPA that limits our work within 12 months.
Madam Chair, thank you. Yes, the only thing I wanted to bring to your attention is there was a reference in the heads of argument of our learned friends to the comparable provisions of the Judicial Service Commission Act. So we've found now the latest ruling by the Judicial Tribunal in relation to whether the complainant, Ms. Mango, was entitled to cross-examine Judge Mbenenge as a complainant, and the ruling was given by Judge Ngwepe saying that she is not, and we just wanted to circulate. But it's not binding, it's just useful background information. So we'd just like to hand that up if the panel wishes to consider it, but it's not strictly speaking necessary.
For what it is worth.
Yes. The only point then is, Madam Chair, I have to leave and I cannot stay for the reply. I'm sorry to Mr. Hali. It's not out of disrespect, but Mr. Ramokhale will stay.
Yeah, please, just one question. Depending on your answer, it may be more questions. But then this question relates to the issue of the argument about hearsay from Advocate Karen van Rensburg. Now, if you look at paragraph 16 of the replying affidavit, in that paragraph, Karen, I beg your pardon, Advocate van Rensburg states that she has been following the proceedings and at times she would even engage with counsel remotely. What is your comment on that one?
No, Madam Chair, that may be so, but she was not involved in the conversations with the evidence leaders. So it simply confirms that it's hearsay, that it was conveyed to her by the person who was involved, but she was not there.
Okay, thank you. Thanks.
Advocate Nkwaitobi, we are not going to level a blame to Advocate Hali because we asked him questions.
Yes.
Of course, even though his answers were long, we had to clarify a few things with him. And as a result, we have breached our own time frames, disadvantaging. You had made it clear that you're going to request to be excused because of your other engagement. And I'm sure Advocate Halley will not consider your being excused as a disrespect to him. So he signals not. So we will excuse you,
Thank you.
and your junior will take that seat as Advocate Halley replies.
Thank you, Madam Chair.
Thank you.
And also tomorrow, I will still be at my tribunal engagement. I'll come back on Wednesday.
Your junior will be leading the witness as you indicated.
Yes, thank you, Madam Chair.
Yes, thank you. Thank you, Counsel. Advocate,
Thank you, Madam Chair.
your reply.
If I can deal with the 5 aspects that have been raised, but in their reverse order. The first is to deal with the issue of the abuse of this process. My learned friend refers in the first instance to the issue of Advocate Norco's credibility and the fact that we've identified that there's a challenge to her credibility. I've referred the panel to the authorities in the to the authorities which deal with the importance of cross-examination, and particularly where questions of credibility might arise. So an attack on the witness's credibility is a very important attack in terms of understanding whether the witness is ultimately to be believed in any inquisitorial inquiry. Then, insofar as the understanding of poker is concerned, obviously we've debated about how important it is to cross-examine different witnesses on the question of poker. Advocate Norco has testified at length. If her understanding of poker is irrelevant, then it does, of course, beg the question why so much time was spent by on behalf of Advocate Chauke in leading her testimony on aspects which are now said to be irrelevant. Then, insofar as Advocate Mutibi's knowledge of the matter is concerned, the point is that it was not a decision taken by Advocate Batoy on her own. It was a decision that was taken by the EXCO, as we've indicated, to launch this application. That EXCO would of course have included Advocate Batoy, but it was a decision taken by that EXCO. It would be, with respect, irrational to think that when a new person comes into office, that the new person has to acquaint himself with everything relating to the decision that has been taken. What he's authorizing is an application being brought for the NPA to participate. The actual factual matrix is irrelevant. Directors of companies take decisions based upon information that they may have no knowledge of. All they need to know is that they need to protect the interests of the institution which they represent.
Yes, I understand that background, that Advocate Mutibi had just assumed office.
Indeed.
And he was not familiar with the background to these matters. If the decision were to be challenged, whose decision would that be? If, for argument's sake, the decision taken was to be challenged, the rationality of the decision was to be challenged, whose decision will that be?
It depends on what. If we're talking now about the decision to institute these proceedings, is that the decision we're talking about? Well, let's assume that there is a basis for the purpose of this argument. That decision would be the decision of the Office of the National Director of Public Prosecutions. It happens to be occupied by a specific person.
Decision, even if he's advised by EXCO but the decision will ultimately be his decision. Am I correct?
The decision would be that of the Office of the National Director. The Act makes provision for the Office of the National Director of Public Prosecutions, of whom the NDPP is the head, with various Deputy National Directors of Public
Yes, thank
Prosecution.
you.
Then, insofar as the fourth proposition under the heading of abuse is concerned, the warning to comply with the timeframes and the fact that we are eating up valuable time in this inquiry, that leads us back to the proposition that we've advanced before. What we are really concerned with is that a full case be presented. What Advocate Chauke is asking for, and what we're asking for in the context of that is that we be allowed to present additional information, additional evidence, and ask questions that have not been asked by the evidence leaders, that has not been presented by the evidence leaders. The panel will always have a right and indeed a duty to sift through everything that is presented in its obligation to control the proceedings, to ensure that evidence is not being led, that information is not being produced, and that questions are not being asked that are merely delaying the matter.
If at the end of the evidence of Advocate Chauke, the evidence leaders will proceed leading their evidence.
Yes.
And it is at that time when the NPA, when it will be open to the NPA to present to the evidence leaders whatever information that they may wish, or you as NPA may wish to present. Will that not be doable? And why, if not?
So, what we're asking for in the first place is a right in addition to that. We will present them with all information.
But why? Why?
Well, we've made our point already, Madam Chair. We've said
If
we.
you are going to repeat what you said earlier, I just want you to understand that the door has not been closed. We are just facilitating finality. When Advocate Chauke's case is closed and the evidence leaders are now ready, if they will be ready with their witnesses, you will have an opportunity as NPA to bring forth the witnesses that you say are available. We don't even know who those witnesses are and what evidence they wish to tender. But as you discuss amongst yourselves, evidence leaders and the NPA team, you will then decide which witnesses you want to lead and what information you wish to present to the panel. Will that not be doable?
I'm just trying to understand what is being proposed to me. If the question being proposed is that if we've got witnesses that we wish to lead, let's deal with witnesses and I'll deal with the other stuff later. If we've got witnesses that we want to lead and the evidence leaders have decided for whatever reason not to lead those evidence.
No. We are not there yet. You have indicated earlier that they have not decided otherwise. And in that event, we'll cross that bridge when we reach it. The point is, when Advocate Chauke's case is closed and the evidence leaders are ready with the witnesses, including your witnesses, I suppose, why can't we proceed with those witnesses, including your witnesses?
No, we're not saying that we can't. I think the purpose of today's application is simply that we should be allowed to lead evidence if they choose not to lead evidence. That's the purpose.
If they choose not to lead that.
Correct. whether it be witnesses, whether it be evidence, whether it be a question that is being posed, that we wish to ask, but which they don't. And if I might just add.
But we don't know whether it will happen. So why do you have to give you a relief of something that has no basis, factual basis? Because if that happens, Council, that's why I say we'll cross that bridge when we reach it. If that happens, you have to bring it to our attention. There's no reason why you cannot be afforded an opportunity to lead witnesses or to bring information forth that may be relevant to this inquiry. If the evidence leaders decide not to present that information, I did not understand your application to be based on that if the evidence leaders in future decide not to tender the information that you present to them or the witnesses that you bring to their attention, then you seek this relief that you are seeking. I did not understand your case to be based on that, at least by reading of the founding papers.
So that is the basis of the application, Madam Chair, that it's an anticipatory application in the first instance, and to the extent that information, because one of the issues that has been raised, but importantly, at the time when the application was launched, at that point in time, we had only been dealing with one witness who had testified, Advocate Norco, come and gone. But those are not the only aspects of what we are raising. One of the things that we've pointed out in the papers was that when it comes to, for argument's sake, we must be allowed to raise in objections. We also have to be allowed to raise objections if there's a valid basis. There's at least two illustrations of that, but the one illustration was the objection raised by Advocate Mchweni against the leading of witnesses, Advocate Norco at the time, where not Advocate Norco, Advocate Maema at the time, where the concern that was raised was that Advocate Maema was simply been told this is the information.
Remember, you are replying.
I do, I understand.
You have to confine yourself to a reply.
You've asked me a question, Madam Chair, and I'm responding to the question.
Yes, I think you've made your point on that. I've noted what you said. You can deal with the next aspect.
Then, with regards to the prejudice to Advocate Chauke, the truth is that we are all under severe time constraints over here, some of which has been imposed upon us simply by the legislation. That can't entitle a witness. If the evidence leaders were to take a view of the matter to lead all evidence in the way that that would cover also the ones that we wish to ask, then how would that prejudice be different from what we are proposing? We are proposing simply that all aspects need to be canvassed. What Advocate Chauke has in mind is that he only wants to be cross-examined by the evidence leaders, and him and his witness only be cross-examined by the evidence leaders, and that he and his witnesses not be subjected to questioning on the full gamut of evidence. If there's a question that is posed by myself or the team on behalf of the NPA, then it must be so that the panel believes is objectionable in any way. Then it must be so that the panel must intervene and prevent the question from being asked, if it is so. But he's asking that those questions must in advance be, the opportunity to pose those questions must in advance be disallowed.
Sorry to interrupt. I don't think Advocate Chauke's case is that he does not want to be cross-examined on the whole evidence that was led. What I understand Advocate Chauke's case is that he doesn't want to be subjected to cross-examination by two parties, which does not stop any questions that the NPA might have to be given to the evidence leaders to be posed to Advocate Chauke. I didn't get their case to say we want to be cross-examined on very limited issues.
Yes,
Thank you.
I accept that. I accept that that's what he's saying. I'm cutting through all of that. And I'm saying to you, if that is his proposition, I don't mind being asked these questions. I just mind it being asked by you, Advocate Hali, or by you as the NPA. Then the question is, wherein lies the prejudice? Because it's been contended that there's prejudice in that. How is that prejudicial to him? His contention is that he doesn't want to be asked questions by two different people, irrespective of whether those two different people who may ask those questions, together, when put together, they cover the full gamut. So what I'm saying is that shorn of all his arguments, it is so that what Advocate Chauke is proposing is that he in fact doesn't want to be cross-examined on the full gamut. That's my proposition.
What is your comment on the possible conflict if you were to cross-examine Advocate Chauke? Very briefly.
Pardon me, Madam Chair, the possible?
Possible conflict on your part.
What? I don't see any conflict at all.
If you were to cross-examine Advocate Chauke?
Well, it's never been raised with me. In fact, it was canvassed during, it was canvassed in chambers. There was never a suggestion that there was any conflict. If I understand...
You can just answer that there's no conflict. You don't have to believe
I'm saying there's no conflict. But to complete that, because it was something I was going to address, to complete that, the first thing that has been raised by our learned friends for Advocate Chauke is that although he had raised it, the decision had been taken that they were not going to pursue it, and it certainly hasn't been raised with me up until now. So you can't both advance the proposition, then at the same time stipulate that you're not advancing it. How does one respond to something like that? So we're not proposing, in a nutshell, that these proceedings should be prolonged in any way. We're proposing only that the proceedings should engage with the full factual gamut of information that is available. If it should so arise that we purport or we attempt to introduce evidence or to ask a question or to cross-examine on any issue that is not relevant or somehow objectionable, then of course that objection will be raised and the panel will deal with it at the time. Then,
sorry, Advocate Hali, and I'm sorry to do this to you
Not at all.
repeatedly. On the issue of conflict, you've penned an opinion which was adverse to Advocate Chauke. Now, you cross-examining Advocate Chauke wouldn't be that. Remember, bias is perceived, whether it's there or not. But if the receiver of the treatment perceives bias, then it should be investigated. Wouldn't you cross-examining Advocate Chauke and in the background of you having penned an opinion that is adverse to him, be seen as you defending your own opinion that you have penned?
so I think we want us to distinguish, Madam Baloyi, Mary, between conflict of interest and perception of bias. The two are not necessarily the same, although they could dovetail. The conflict of interest arises from one's involvement or potential involvement where you're protecting where you've got an interest in one capacity with an interest in a different capacity. And in the present case, if there's a suggestion that there's a conflict of interest, it obviously ought to have been raised with me in the first instance. And in the second instance, then I would know what the factual basis is to it. but the perception that I might be biased, I'm not even sure how to respond to that. There isn't such an assertion at the moment, but I imagine that it might have the seeds of such an assertion may well be lingering there. But I'm not sure what to respond to something like that because I don't know what the factual basis is for it.
If the basis could be that you have already expressed a view in your legal opinions that were presented to the President, which has brought us here, will that not constitute a perception of bias?
Well, with respect, any prudent litigant would often request his or her counsel to express a view on the merits or the demerits of his case. If that is a basis to say that that particular counsel is then disqualified, with respect, that cannot be right, Madam Chair.
We are far beyond 15 minutes. Just wrap up, please.
Thank you, Madam Chair. Insofar as reliance has been placed upon the contention is that with reference to the cases that have been cited, the provisions of Section 33 and PAJA have been excluded from an organ of state. And reference is made to a long line of authorities on that proposition. Sorry. Can I ask that you consider the judgment that has been referred to by our learned friends in that regard, and I'm just trying to find it while I sit here, but the judgment that has been referred to, I think it's the Curlin judgment. One need only consider paragraph 2 of that Curlin judgment, where the court says in explicit terms that it excludes the situation where an organ of state is itself the subject of an application or of administrative action. So in other words, it applies on the facts of that case where an application is brought by the organ of state who seeks to self-review, as it were. And the court makes the point that in those circumstances, you wouldn't be entitled to rely upon the provisions of the PAJA. There is, as far as I'm aware, there is authority that says very much the same in the context of an application brought by an organ of state, where the organ of state is itself now the subject of administrative action being exercised by another organ of state. And it seems to confirm that within that space, the first organ of state wouldn't be entitled to rely upon the provisions of PAJA. But we must understand the source of PAJA. PAJA was intended to give rise to codify the provisions of Section 33(1). The original source of that was Section 33(1) of the Constitution. PAJA, as I understand those cases and as I understand the Curlin judgment, they concerned with the application of PAJA to organs of state. It doesn't inhibit or doesn't prevent an organ of state from coming in under a different provision, which would have been the provisions of Section 33(1). Even before the Constitution was enacted, organs of state had the right to, under the common law, to bring an application to review the decisions of other organs of state and to review the decisions, their own decisions. It did so under the heading of the administrative justice, but that was prior to the Constitution. If Section 33(1) gives rise to that right, but PAJA doesn't extend it to organs of state, then we would submit that the right is to be located then in terms of Section 33(1).
Well, we will consider your
Indeed.
written submissions on whether PAJA applies or not.
Indeed, but my case is not limited to PAJA. I thought I'd made that quite clear.
Yes, your case is covered also in your written submissions, the rule of law principles, legitimate expectations, Audi, rules of natural justice, all those principles that you espouse in your written submissions.
Thank you, Madam
We
Chair.
will consider them.
I appreciate that.
And the case law, of course, that you referred us to, which actually made us to work until early morning.
I apologize profusely for that. There's just perhaps one other thing that the suggestion, if I can, just to the suggestion is that there is somehow an insult against 4 black advocates. There's no suggestion at all, none on the papers. That is a suggestion that Advocate Chauke has sought to make. We have not said that at all. And the suggestion
You didn't
that
want us to get in that debate, Council.
I also
because,
didn't want us to get into that debate.
Yes. You remember when we started, right at the outset, the communication that was presented to us in writing, where certain insinuations, I drew your attention to a very patronizing statement in one of the letters. And I didn't take kind to that personally. I thought that that was not in good taste. And I think we can leave it to rest, because we don't want to get into those arguments about black, white. But we should not create an impression when we write to one another, or even to the panel, that some of the advocates that who have been appointed don't have what it takes. We should not create that impression.
Indeed, Madam
In
Chair.
any
but
way.
we didn't create that impression.
Yes, that's why I don't ask to go there, to
Thank you,
get
Madam.
back to those letters. We discussed it in chambers with the parties, all of you. And we caution that we need to respect one another in what we write, in what we say to one another. So I propose that we don't go back and forth about it. It is not going to help us in deciding the very issues that have brought us here. But it is all the question of respecting one another as parties, as lawyers, as judicial officers, as the panel. We owe it to one another. So I suggest that we don't go there to argue that point. Is not going to help us to decide the issues. Any other aspect in reply?
Only to conclude by saying that it is not anyone's proposition, and certainly not mine, that only I am capable of dealing with this matter. That's not the proposition at all.
Yes, thank you. Thank you, Advocate Halley. Thank you, Advocate Chauke's team. We will consider your submissions and prepare a ruling. It may take a little bit of time because we have to come back and hear evidence every day. And we don't have time at our disposals to write that ruling quickly. But as soon as we are ready, hopefully during the course of this week, we will alert you.
We appreciate that. Thank you, Madam Chair.
Yes, thank you. Advocate, I almost said Advocate Nkabinde. Yes, Counsel, is the witness ready?
Chair, we had arranged with the witness to be ready from 12 o'clock, which would be the time at which we would be back from tea. I don't know, sitting here, whether she's actually ready and if everything is set up, but she should be at the premises of her attorneys.
Yes, please apologize on our behalf. We will apologize to her when she takes the stand. She must have been waiting since this morning.
Yes, indeed, Chair.
We will take a tea adjournment. We will adjourn until 12:30 and start with that witness by 12:30.
Thank you, Chair.
We adjourn.
And our first witness from KZN.
Please place her names on record so that I can talk to her.
Madam Chair,
Good afternoon. Okay, tell me.
my apologies. I was going to say we'd now like to call our third witness, or rather second witness now, which is Ms. Shamila Henrietta Williams.
A very good afternoon to you, Ms. Williams.
Good afternoon, Commissioner.
Thank you very much for making yourself available, and our apologies for having kept you waiting this whole morning.
Not a problem, Commissioner.
We got held up by argument in an application that we were dealing with this morning. I'm sure you understand how these things happen.
Yes, I do.
Yes, thank you very much.
Thank you, Chair. Before we start, I just wanted to check whether Ms. Williams can actually see us. I'm not sure if in the setup she can actually see the people in the room or not.
Do you see me?
No, I'm not able to see that. No, Commissioner, I do not see anything from our side.
You are at a disadvantage. We see you so well, but you don't see us.
At least I know what you guys look like, Commissioner.
Thank you, Chair. With your leave. Ms. Williams, I'm
I
sorry.
have to swear her in
Yes, yes, I'm
first.
sorry.
Madam, what is your rank?
I was a senior investigator at the ICD that then became the IPAT, Commissioner.
How do I address you?
Ms. Williams.
Miss Williams. You
That's
happy
correct,
with that?
Commissioner.
Yes, thank you. Miss Williams, do you prefer to take an oath or make an affirmation? An oath
An oath
or
is,
affirmation?
an oath is good. An oath is good, Commissioner.
Yes, thank you. You may refer to me as chairperson.
Got that, Chairperson?
Yes, ma'am. Thank you, ma'am. Do you swear that the evidence you are about to give will be the truth, nothing else but the truth? If so, raise up your right hand and say, "So help me God."
So help me God.
Thank you, madam.
Thank you, Chair. Ms. Williams, you have provided a written statement to this panel. Do you have that statement with you?
That's correct, Chairperson.
And if we could go to the second page of that statement, you'll see at the top right corner it says 3-2. Do you have that?
No, just hold on. No, I do not have that.
What appears on the second page of your statement?
That's my name.
Right.
And a short resume.
Yes. And then at the end of that, on page 50,
Just Chairperson, page 50.
50, yes, 50.
Okay. At the bottom of page 50, it's my signature and my name.
Thank you, Ms. Williams. I see, though, that the statement doesn't have a date. Can you confirm to the panel the date on which you signed the statement?
The date on which I signed the statement would have been on the 2nd of March, 2026, Chairperson.
That would be today.
That's today's date, correct, Chairperson.
And did you read the contents of the statement carefully before signing it?
Yes, Chairperson, I read the statement thoroughly and I agree with what is said on here.
And do you confirm whether they are true and correct to the best of your recollection?
Yes, I do confirm that it's correct to the best of my knowledge, Chairperson.
And do you consider the contents of the statement binding on your conscience?
Yes, I do, Chairperson.
Thank you, Ms. Williams. Chair, we haven't agreed on a particular protocol for virtual hearings, but I do see that there's a hand at the bottom left corner of Ms. Williams. Could she just confirm who is in the room with her?
Chairperson, my attorney, Peter Allen, is here with me.
Chairperson, unless there's no issues with her having the assistance of her attorneys, I'd like to proceed.
I don't foresee any problems, but as you are testifying, you are under oath. You are not going to discuss whatever you are testifying about with anybody, correct?
No, Chairperson. Yes, Chairperson.
Thank you, Ms. Williams. Could you begin by telling the panel when you first joined the South African Police Service?
I joined the South African Police Service in the year 1991, directly out of high school in March. I became a student constable and I attended my training at Bishop Lavis Training College in the Western Cape. My training was completed in and about September of 1991, Chairperson.
And what
I
was
was
your...
then stationed at...
I'm sorry, I was going to ask, what was your first posting after your training?
My first posting after my training was at Bloemfontein Flying Squad. I worked from there from September 1991 until I think somewhere in 1993.
And over the course of your career at the South African Police Service, what positions did you hold?
I was a constable at this stage, and then I was transferred to East Rand Radio Control in Benoni in 1995. I was then transferred to Benoni Police Station in 1996, where I became a sergeant, and I was working in the administration section in the beginning, and then towards 1990, I think in February 1996, I became a detective sergeant.
And in paragraph 7 of your statement, you speak about your career in August 1996. Could you tell the panel more about that?
Yes, in August 1996, Chairperson, I joined the SAPS Family Violence, Child Protection and Sexual Offences Unit in Benoni, also as Detective Sergeant. At FCS, I specialized in investigation of crimes against vulnerable groups, including gender-based violence, child abuse and sexual offences. My detective work in FCS unit focused on sexual offences and domestic violence.
And what did your duties include?
My duties included investigating cases related to gender-based violence and serious criminal offences, conducting witness interviews and compiling detailed investigation reports, preparing and distribution of SAPS press releases, attending court proceedings and regular operational meetings, maintaining and updating all investigative and administrative records.
And then in paragraph 9, you tell us about what happened in August 1999. Could you tell us more about that?
Yes, there was an incident in 1999 where a colleague of mine and myself were involved in a near-death incident in Davidton and Benoni. And that actually affected me a lot, and I decided to leave the police, and I pursued Christian ministry up until about 2002, where I took up employment as an administrator in the private sector. I then joined ICD in June of 2006, where I was employed as a senior investigator. By the time I left, it had become IPID, and I left in 2014, August.
And for the people watching at home, what's ICD?
ICD is the Independent Complaints Directorate, Chairperson.
And you tell us at paragraph 10 that you were a senior investigator there. As senior investigator,
Yes.
what was your mandate and duties?
My mandated duties was to conduct investigation into criminal offences involving members of the South African Police Service as well as Metro Police, conducting witness interviews, collecting and preserving evidence, liaising with technical experts including forensic pathologists and ballistic experts, compiling investigation reports and memoranda for the IPID management, the Director of Public Prosecutions and SAPS, managing multiple high-priority cases simultaneously, attending court proceedings and internal departmental hearings, ensuring compliance with investigative protocols and documentation standards.
And then in paragraph 12, you tell us at IPID that you completed various training courses. Could you tell the panel more about that?
Yes, Chairperson. While in IPID, I completed various training courses, including specialized training in sexual offences, torture-related cases, and asset forfeiture. I left IPID in August of 2014. The circumstances of my departure were unhappy. I've always been someone who does not keep quiet when a wrong has been done. I ask questions and challenge authority. These traits have strained my relationships with and alienated colleagues, but they've also driven me to fight for to investigate cases involving serious wrongdoing that no one else wanted to investigate. Unfortunately, my persistence in investigating matters in the face of opposition from our IPID colleagues and SAPS members made me a target.
Ms. Williams, we'll come back to that a little later. And if I could ask you to speak a little slower. The panel's trying to make notes as you're speaking, and it's difficult to follow at the current pace. Could you just tell us...
Thank you, Council.
Thank you, Chair. Could you just tell us, in the course of the work that you did at the ICD, what kind of matters were you investigating?
At IPID, what we were investigating was death in police custody, death as a result of police action, misconduct conducted by police officers as well as Metro police officers.
Sorry, Ms. Williams, just a little slower, please. So the first one was?
Death as a result of police action.
Yes.
And then death in police custody.
Yes.
And then misconduct by either SAPS members or Metro Police members.
Yes, and any other kinds of matters? Just those three?
Yes.
And then do tell us, in the course of your work at IPID, and we'll get into more details with this later, did you make any recommendations either to the police or any other organs of state?
Yes, I would have made recommendations to the police as well as the Director of Public Prosecutions and also IPID management.
Now, we will skip over paragraph 16, 17 of your statement. Rather, actually, let's skip over paragraph 16. If you could just read what is stated at paragraph 17 of your statement.
I am well placed to address the allegation because as a senior investigator in the erstwhile Independent Complaints Directorate, also referred to as ICD, now the Independent Police Directorate, IPID, I investigated a number of the killings which formed the basis of that prosecution. In particular, I investigated the killing of members of the KwaMapungulu Taxi Association, also known as KTA, in the course of Cato Manor, SVC, purported investigation into the killing of SAPS Superintendent Kono on 27 August 2008 and in Nkosi Zondi.
Yes, and in paragraph 18?
In some of the Cato Manor cases I investigated, I was the lead investigator assigned to conduct the ICD's statutory mandated investigation into the killings. In fulfillment of its role as the independent body responsible for overseeing the police and ensuring police accountability for deaths as a result of police action, those matters were Berea Case 288 of 5/2008, Durban Central Case 185 of 2/2009, and Kwamashu Cares 698 of 11/2009.
Yes, please go on.
As a direct result of my investigation into the killing of Mr. Bongani Mkhize, Cares 185 of 2009, I also took the initiative to have the ICD's investigation into other KTA killings reopened. Those matters were Kwadukuza Cares 39 of 9/2008, Howick Cares 106 of 9/2008, and Mandini Cares 76 of 9/2009, as well as Umkoma's Cares 235 of 10/2008.
And then you tell us information.
In total,
Yes, go on.
In total, I was the original lead investigator in 3 of the 23 murder dockets identified by the NPA for prosecution, and conducted a re-investigation into 4 dockets concerning the killing of KTA members by members of the Cato Manor SVC between late 2009 and around August of 2010. I also attended the scene of other killings included in the 23 dockets, although, as I have explained below, I was not the lead investigator in these matters and was not involved in the investigation beyond assisting the lead investigator to conduct an initial inspection of the scene.
Yes, in paragraph 16, and we'll come now to paragraph 21, you state that you are familiar with the terms of reference of this inquiry, and that a central allegation is that Advocate Chauke supported and advanced the decision to prosecute the Cato Manor unit, notwithstanding that there was no evidence justifying that decision. Could you provide an explanation, I think it's in paragraph 21, why you say that you're familiar with the terms of reference and why it is that you've decided to give evidence to this inquiry?
Okay. The prosecution that lies at the heart of this inquiry arose from the reopening of the ICD and IPIT investigations by a joint IPIT and Directorate of Priority Crimes Investigation, DPCI task team, established in late 2011 following the Sunday Times publication of Shoot to Kill inside the South African Police Death Squad, an expose on the killings committed by the Cato Manor SVC. The IPIT task team's investigations commenced several months after my investigations into the KTA killings were interrupted by an inexplicable decision by the DPP's office to send the dockets to a formal inquiry instead of prosecution. I was not a member of the 2012 IPIT task team, nor was I consulted when it commenced in what would be a 3rd round of investigation for some of the dockets, Chairperson.
All right, we'll pause there. We'll come later to what you state there in paragraph 21, that your investigations were interrupted by an inexplicable decision by the DPP's office to send the dockets to a formal inquiry. Could you then carry on in paragraph 22?
The purpose of this statement is to provide the panel with an account of the role played by the ICD and later IPIT in the investigation of the Cato Manor killings, and a perspective on why, despite the existence of these oversight bodies and their investigation into these matters, the members of the Cato Manor SVC were not held accountable. I address these issues with reference to number 1, Chairperson, the mandate of the ICD and the IPIT, and the institutional framework within which they operate. An overview of the ICD and IPIT's involvement in the Cato Manor cases. An overview of my personal involvement in these cases. A chronological account of this involvement, beginning with when I was assigned as lead investigator in Berea case, 288 of 5/2008. My assessment of what went wrong in these matters and how and why the ICD and IPID failed the victims of these crimes.
Thank you, Ms. Williams. And then in paragraph 23, you tell us that there are certain things that you cannot comment on. Can you tell the panel about that?
Yes, Chairperson. Before addressing these topics, I emphasize what I cannot comment on. I am not in a position to comment on the investigations conducted by the ICD into all of the 23 matters that form the basis of the 2012 indictment. I can comment on the 7 matters I personally investigated. For those matters in which I was only present for the initial inspection of the scenes, I can only speak to what I remember observing at the scene, as I was not involved in the subsequent investigation. I am not familiar with the investigation that was conducted by the task team in 2012 and the further evidence which it did or did not uncover. I can confirm, however, that the evidence I gathered in the course of my investigation in the above matters was, in my view, sufficient for a successful prosecution of murder charges against the relevant members of the Cato Manor SVC.
Thank you, Ms. Williams. We will skip over paragraphs 24 to 28 and get right to paragraph 29, in which you inform the panel about the importance of an independent police watchdog, I'll call it. Why do you say so?
I'm going to read the mandate, section 29. Section 206 of the Constitution provides for the establishment of an independent police complaints body by national legislation. Pursuant to this, the Independent Police Investigative Directorate, IPID, was established in terms of the IPID Act, which came into force on 12 May 2011. Section 2 of the Act assigns IPID an oversight role over the South African Police Service and municipal police services. The forerunner to IPID was the Independent Complaints Directorate, ICD, a notionally independent body established in terms of Section 50 of the South African Police Service Act 68 of 1995.
Right.
From my experience as an
I'm sorry, Ms. Williams. Before we get there, we'll come back to paragraph 31. In paragraph 30, you say that the ICD was and I'm quoting here, a notionally independent body. Why do you call it a notionally independent body?
IPID was supposed to be operating independently from the South African Police Service.
Yes, and what made it fail to operate independently from the South African Police Service?
The ICD at that time was reporting to SAPS, and which in my opinion, I thought that they were supposed to only report to the then Minister of Police, but that was not the case.
So what's wrong with that? So the ICD is set up as a structure reporting to SAPS, and your view is that it should have gone to the Minister. What's the problem with that?
The problem that I had with that is that we are reporting to the very same people that we are supposed to be investigating.
Right. Then paragraph 31.
From my experience as an ICD investigator, I understand that independent oversight of the police is essential in a constitutional democracy. The police exercise significant powers, including the power to arrest, to use force, and in certain circumstances, to use lethal force. Because of the seriousness of those powers, there must be an independent body that investigates allegations of misconduct, brutality, corruption, or unlawful killings involving members of the police. One form of oversight is an independent investigation.
Yes, please go on.
One form of oversight is an independent investigation into potential wrongdoing by the police, including deaths as a result of unjustified police action, death while in police custody, torture, and sexual violence by members of the police. This has been a critical function of both ICD and IPID.
Yes, please go on. Paragraph 33.
Such investigation, Chairperson, are not only important for the individuals directly affected, but also for maintaining public confidence in the police service. Where deaths occur as a result of police action, or where serious allegations are made against police officials, it is vital that those matters be investigated thoroughly, impartially, and without any actual or perceived interference. Only in that way can accountability and transparency be ensured.
And then in paragraph in paragraph 34, you state there to the panel that there were serious structural defects. Could you tell the panel more about that?
However, as I explained below, Chairperson, there were serious structural defects in the ICD that made it a toothless organization. While it was notionally independent, it reported directly to SAP's commanders about its investigations.
And then in 35, you tell us that the ICD was then replaced by IPID in May 2011. Is that correct?
That's correct, Chairperson. The IPID was then replaced by the IPID in April of 2012.
Is it May 2011 or April 2012?
The IPID Act actually came into effect in April of 2012.
So is that an error, what we see there at paragraph 35?
I think the error must have been prior to that because the Act started in April of 2012.
All right.
That's when IPID started operating.
Chair, I just want to check whether the version you have has that error or not, the version that the panel has. Paragraph 35, page 3-10.
Ascertain first with you. Remember you sent us a version that we read last night.
Yes, Chair.
This version, is it the corrected one?
This is the one the panel has with the signature is the corrected version.
Is it correct? It should be the amended one.
Yes. So it reflects, just to confirm, it reflects April 2012 in paragraph 35. Thank you. Sorry, Ms. Williams. Now, I've got the old version here, so we'll go on the one that was corrected. So you continue then in paragraph 35. Would you please read that?
Accordingly, the oversight body that investigated many of the Cato Manor cases that are the subject matter of this inquiry, which concerns incidents taking place in 2008 and 2009, was ICD. Further, due to the establishment of task teams to investigate the Cato Manor killings in December 2011, they were also investigated by an IPID task team in the course of late 2011 and early 2012.
Yes, please go on.
My experience was that whilst IPID was given more bite in terms of its powers, it functioned in a very similar manner to ICD, although regulated by different legislation and regulations. I briefly outlined the statutory framework in which the ICD operated and the current framework under the IPID Act. I then provide a high-level overview of the ICD and IPID's investigative process.
Yes, before we get to...
the independent...
Sorry, Ms. Williams.
Yes.
Sorry, before we get to that, I just have one question to clarify with you in respect of paragraph 34, in which you say that there were serious structural defects in the ICD that made it a toothless organization, and that whilst it's a notionally independent organization, it reported directly to SAP's commanders. I just want to know, in your experience as a senior investigator of ICD, how did this affect your work?
It affected the work in where you were limited in what you could do and what you could get from SAPS. Because when SAPS actually closed ranks on you, there was nowhere else to go, and it made your work to find evidence or speak to even SAPS members very difficult.
So it affected your ability to cooperate with the SAPS. Am I understanding that correctly?
Your understanding is correct, Chairperson.
All right, you were about to read paragraph 38 and onwards of your statement. Please do.
Chairperson, the Independent Complaints Directorate, the ICD was mandated to investigate, amongst other matters, allegation of serious misconduct by members of the SAPS, as well as deaths in police custody and deaths resulting from police action. These were regarded as particularly serious matters because they involved the use of state power and in some instances the loss of life. It was intended to operate independently of the SAPS. However, such independence was not secured in the manner the ICD operated. In my experience, while the legislation expressly prohibited any interference with its work and required other organs of state to respect and protect its independence and effectiveness, this often did not happen, and there were no mechanisms available to enforce this against SAPS. As far as I recall, the only way of addressing non-cooperation from SAPS was to go directly to the KZN Head of Detectives, Commissioner Brown, and hope that he would intervene.
Could I ask you about paragraph 39 a little more? Outside of addressing issues with Commissioner Brown, as you say in paragraph 39, did the ICD have any other mechanisms of enforcing cooperation with the SAPS?
I suppose then they would have to speak to whatever provincial commissioner there would be and engaging them in getting what we wanted.
So you had said earlier that one of the ways ICD operated was to report back to SAPS. Is the mechanism...
That's correct, Chairperson.
Sorry, is the mechanism that you are referring to now the same? That if you needed more cooperation, you just have to go back to SAPS again?
That's correct, Chairperson.
And outside of SAPS, as the ICD, did you have any other mechanisms of enforcing cooperation?
Not that I was aware of, Chairperson.
So then what would happen if SAPS did not cooperate?
If SAPS did not cooperate, then you would be at a loss. There would be nothing else that you would do. If they don't cooperate, then your investigation is not going to go anywhere.
Thank you, Ms. Williams. And then in paragraph 40?
Whilst deaths in police custody or resulting from police action are not matters that should be investigated by SAPS itself, the practical reality of the manner in which ICD operated meant that in many investigations, it was SAPS that did the investigative work, with the ICD investigator monitoring the investigation. As I explained further below, the ICD did not have true institutional independence from SAPS. There were parallel SAPS investigations into the same incidents. The ICD was not permitted to interview police officers involved in the shootings at the scene of the shooting. Instead, their versions were relayed to us by SAPS duty officers at the scene.
Right. We'll come back to that later, but I just want to ask you another question based on the answer you've just given, which is that if you had no cooperation from SAPS, that would be what would happen to your dockets, your investigations?
When we have no cooperation from SAPS, whoever else witnesses that you secure, that is all that you will have. And then you will have to wait until SAPS one day decide that they will cooperate with you. And that was not always the case. There wasn't much that myself as an investigator could do. You would go to your management and ask them for assistance. And then you will have to wait for SAPS to respond.
And if there's no response from SAPS, what then would become of those investigations?
Absolutely nothing. Your investigation will not go to where it's supposed to go to.
And where would that be? Where would the where's the investigation supposed to go to?
If you want to have a prosecution, for instance, if you want to get more information from your SAPS member as to what had transpired at the scene, if they're not going to cooperate, there's nothing else that you can do about it.
So the investigation becomes what? Does the ICD close its file? What does it do with that?
The ICD would normally close its file.
And then here,
Council,
I'm sorry.
paragraph 39. Ms. Williams, paragraph 39, the second sentence. It is not clear to me what it means. You are dealing with the ICD when you look at paragraph 38. Paragraph 39, it was intended to operate independently of the SAPS. However, such independence was not secured in the manner the ICD operated. Would you please elaborate there?
Yes, Chairperson. Even though the Act says that we have all these powers, there wasn't much that we could do. We also always relied on SAPS cooperation for our investigation, to further our investigation if we wanted to secure prosecution or things like that. And that was not always the case, because sometimes you got stonewalled and the police closed ranks on you.
Yes, thank you.
thank you, Ms. Williams. And then in answer to the chairperson's question, you make mention there in paragraph 40. Could you just elaborate what you state there from, as I further explained below, the ICD did not have true institutional independence from SAPS. Could you just, in your own words, do you have that?
You said paragraph 40.
40. You say, as I explained further below. Chair looks like
Okay.
oh, there she is.
Okay.
You say, as I explained further below, the ICD did not have true institutional independence from SAPS. And the chair is asking you, what do you mean by that, particularly because in 39 you say independence was not secured in the manner in which the ICD operated. Could you just explain more what you mean by that?
ICD was always reliant on SAPS to provide us with everything. From ballistic reports, LCRC, everything that you needed came from SAPS anyway. So you had to wait for them to provide you with reports. If you wanted to speak to, say for instance, suspects, you would have to wait, and if they do not want to give you an explanation, there was nothing that you could do about that.
Did ICD not have that internal capacity itself?
ICD did not have the internal capacity itself.
And then you mentioned there in paragraph 40 that there were parallel SAPS investigations into the same incidents. Could you explain how that came to be?
At times, I will explain it this way, Chairperson. There would be a shooting, a death as a result of a police action. And then SAPS would have their investigation that they are conducting. ICD would have a separate investigation that they were conducting at the same time. So both of them would be doing exactly the same work.
So wait, so SAPS is conducting an investigation, is that correct?
That's correct, yes.
And
Their own
ICD,
investigation.
and ICD is conducting an investigation into the same incident.
That's correct, Chairperson.
But how does that work? Isn't, you've told us that the ICD was the investigator into SAPS. Why is SAPS conducting an investigation?
In most instances, and I think the best way for me to explain this, Chairperson, if ICD had decided that they are not going to conduct full investigation, then SAPS would be conducting the investigation themselves, and IPUT would monitor the investigation into the SAPS, what the SAPS are doing. We would also have our own independent investigation that we would conduct, obviously to check, to do checks and balances to see whether the investigation conducted by SAPS was going into the correct direction.
Right, so you've now mentioned two things, which is you would do an investigation and you would be monitoring an investigation.
That's correct, yes.
I still don't understand that. How's that possible? I mean, the police watchdog is monitoring a police investigation?
That is what happened in practice, Chairperson. that we were monitoring police investigations to see what the police were doing in their investigation, and then we would take our cue from that.
Right. Now, what would happen in the instance where the police did not want to conduct an investigation, but the ICD did?
That's not what really happened in practice. ICD was always the ones that decided which investigations they were going to conduct. It wasn't all investigations as a result of police action that was investigated by the ICD.
It wasn't all incidences that were investigated by the ICD.
That's correct, Chairperson.
I think your statement speaks more about that particular process later, so perhaps we'll get a little bit more clarity later.
Okay, good.
Then the third thing that you say in paragraph 40.
Maybe just before you proceed, I'm trying to understand what you say about the apparent cross monitoring. Mrs. Williams, you say in most instances where the ICD has decided that it is not continuing investigation, SAPS would do the investigation, which would be monitored by the ICD. Am I correct thus far?
You are correct, Chairperson.
Okay. Now, upon the SAPS completing the investigation, would the ICD then have the power to then maybe make recommendations about that matter that has been investigated by the police?
Yes, ICD will then make recommendations based on that.
But then would there be an instance where ICD has decided not to proceed with the investigation, the police decide to proceed, and then the matter never comes back to the ICD? Or what is the position? Would the monitoring be in respect of all matters, or would it be in respect of selected matters?
That, Chairperson, would obviously be in respect of selected matters.
What would inform the ICD as to in respect of which matters? Because I think we're talking about matters that involved the police conduct in this case. Now, in respect of which would, or what would inform the decision to, yeah.
Yes, Chairperson, I understand your question. What would happen is you would attend the crime scene, say for instance where shooting occurred. And what we normally would do, we would make inquiries and find out what exactly happened, that led to the shooting. We needed to establish that. And then based on the information that we find at the scene, it would normally sort of give you an indication whether the shooting was justified or not. And based on that, the ICD would then make a decision whether they are going to conduct full investigation or whether they are going to allow the South African Police Service to continue with that investigation, and then the ICD would then monitor that investigation.
Would the investigation docket be closed without the final word from the ICD? I'm talking about these cases where the ICD would be monitoring progress in.
Yes, Chairperson, the ICD would not have any input in those matters.
Thank you.
So you're saying there are matters that you were monitoring and matters in which you were conducting what you've now just said is a full investigation?
That's correct, Chairperson.
And you've informed the panel insofar as those that you were monitoring that you were just monitoring it, but you had no input into the investigation?
That's correct, Chairperson.
And would the situation be different with a full investigation?
The situation would be different with a full investigation, Chairperson, where you would be the one that's solely responsible for the investigation of the matter.
All right. Thanks, Ms. Williams. And then in paragraph 41, could you just read what you've stated there?
In practice, when a death occurred as a result of police action, ICD officials would attend the scene and complete what was known as a crime scene report. This was a basic and preliminary document recording the circumstances as presented at the time, including the location of the incident, the identity of the victim, and the identity of the police shooters. Thereafter, an investigation would follow, but this was not necessarily a full investigation. A more comprehensive ICD investigation would only be authorized if, after a preliminary assessment, the ICD formed the view that the killing may not have been justified. It was at this stage that a full investigation would be undertaken by the ICD. The ICD would effectively take the investigation over from SAPS, converting the SAPS docket into an ICD docket maintained by ICD.
Apologies. In paragraph 41, you've mentioned there of a crime scene report. Just again, in your own words, just explain what that document is.
It's a crime scene report, ICD 7/2.
And
This is
ICD
a
what,
report.
sorry?
7/2.
What is that?
It's a crime scene report.
So no, when you say a crime scene report is ICD/7/2, I'm asking what is ICD/7/2?
That is a crime scene report that is then compiled by the ICD, where we gather all information relevant to whatever crime scene that we are attending.
So it's what, a form, a document?
Yeah, it's a form that we complete, a pro forma that was that the ICD used.
Right. Sorry, I interrupted you. You were still explaining what a crime scene report is?
Crime scene report is what ICD used to record all relevant information that is gained from a scene when you go there. Everything that, every witness that you interviewed, who the shooters was, all the relevant information that we would use to then further conduct an investigation that would assist us in doing so.
Thank you. And so you just walk us through the steps. You've already informed us a little bit about that. You told us that you attend to a crime scene, and then what happens?
You attend to a crime scene, you engage the duty officer, because that is the contact person that you are going to speak to from SAPS, that's going to give you all the information regarding what transpired. You get the names of the shooters, you get the story of how this matter transpired and how it came to that the police actually used firearms that resulted in the death of a person, a citizen, a normal citizen. You would get names of all the witnesses involved, the firearms, everything relating to what has transpired, you get at the scene. And you record it as such, because that is going to guide you into your investigation.
And would
I'm sorry. I just missed that, the description of the officer. You say you engage the what officer?
The duty officer.
Duty officer, thank you.
Yes.
And tell us, would all of this information be recorded in the crime scene report?
That is correct, Chairperson.
And that will be the form that you referred to in paragraph 41.
That's correct, Chairperson.
And when you form the view, subsequent to the completion of the form that the killing was not justified, you'll do a thorough investigation.
That's correct, Chairperson.
Will that be followed by a full report?
That would be followed by a full report, yes, Chairperson.
At what stage?
That would always be towards the end of the investigation, and that report would obviously go to the DPP's office.
So you say your reports would go to the... I'm sorry, Chad. I'm not sure if you had another question.
The reports
Chair,
would
may I
go to
proceed?
the director.
So you may proceed.
Sorry, my apologies.
Yes.
So-
No, you just clarify that the form will be followed by a comprehensive report if you formed the view that the killing was not justified. And you answered that yes, and thereafter, that report, that comprehensive report, will then be submitted to the DPP, to the relevant DPP.
That's correct, Chairperson, and that would always happen at the end of your investigation.
Yes, thank you.
Thank you, Ms. Williams. We're now at paragraph 42 of your statement and onwards. If you could just read that and place it on record.
The IPID replaced the ICD as the statutory body responsible for police oversight. Like the ICD, it was intended to function independently of the SAPS and to investigate alleged criminal offences and serious misconduct by members of the police. It was to ensure accountability and transparency within the police service.
Yes, please go on.
IPID's mandate included the investigation of deaths in police custody and deaths resulting from police action, as well as complaints relating to the discharge of firearms by police officials. These were regarded as serious matters requiring independent investigation.
Yes, I think the earlier parts of your statement cover this. And then in paragraph 44.
The IPID investigators are vested with full investigative powers similar to those exercised by police investigators under the Criminal Procedure Act. They are able to secure crime scenes, obtain statements, collect and seize exhibits, attend post-mortems, and where appropriate, effect arrests.
So now just on that, on paragraph 44, your statement begins by saying IPID investigators are vested with full investigative powers. Should we take that to mean that, does this extend to the ICD as well?
Yes, Chairperson, it extended to the ICD as well.
So the ICD, just on your statement in paragraph 44, was able to secure crime scenes?
That's correct, yes.
And obtain statements?
That's correct, Chairperson.
And collect and seize exhibits?
That's also correct, Chairperson.
Attend postmortems?
That's also correct, Chairperson.
And effect arrests?
That's also correct, Chairperson.
And then in paragraph 45?
In cases involving a death in police custody or as a result of police action, IPID investigators are required to attend the scene as soon as practicable, secure and oversee the scene, gather evidence, obtain statements from witnesses, and compile a report with recommendations regarding possible disciplinary action or criminal prosecution. Where the circumstances warranted it, consideration could also be given to the arrest of the member or members involved.
Yes, and paragraph 46?
In my experience, however, IPID functioned in much the same way that ICD did, notwithstanding its enhanced independence. IPID investigation faced the same entrenched limitations that ICD investigations did, including the prohibition on ICD investigators interviewing SAPS members at the scene of the incident, and the practice that IPID investigations are not automatically conducted as full investigations, completely independent from SAPS.
Now, I just want to ask you about that. In this paragraph, you tell the panel that IPID investigations face the same entrenched limitations that ICD investigators did, including the prohibition on ICD investigators interviewing SAPS members at the scene. And this is now the second time this is repeated, because in paragraph 40, you say the ICD was not permitted to interview the police officers involved in the shooting at the scene of the shooting. Could you just explain that to the panel?
When ICD, and even then afterwards, IPID personnel would get to a scene, a crime scene, where somebody has died as a result of police action, or police custody. Police custody wasn't so much of a problem, but the one as a result of police action would obviously be a problem. You are then only going to speak to the duty officer, and you are going to get second-hand information from the duty officer, whereas it would have been better, in my view, Chairperson, when you engage the police officer directly after the incident and to actually establish what it is that transpired at that scene. And that was, in practice, not what was happening.
And what would happen instead? You're saying it's better to go to the police officers directly?
In my view, it was better to speak to the police officers directly, and at a later stage, as my testimony continues, you would see that there's a specific matter where I was able to engage police officers that it actually had a different result.
Which police officers are you referring to?
I'm talking about the members that was involved in shootings, where we normally didn't interview them directly at the scene because we would be speaking to the duty officer. But there is one instance at a later stage, as my testimony continues, that you will actually see clearly that when I speak to the shooters that was involved, that there is actually a different result.
Thank you. You then...
Let me just ascertain. Why so? Is it because members of the subs who would have arrived at the scene before you will close rank and protect their colleagues, or what would have been the position? Why is it better to speak to the shooters directly?
Well, I would agree with you with that closing of ranks. In some instances, and I'm going to be very specific, especially when it came to the Cato Manor SVC, there would normally be one specific person. You didn't speak to anybody else. You didn't speak to any of the members. That member actually took charge of whatever was going to say. I actually labeled it as the SVC spokesperson, and nobody else you were allowed to speak to except to that member.
Just a follow-up to what my sister has asked. You say it was always better to talk to the concerned police officer. But then the question is, were the IPID or ICD investigators barred from consulting or interviewing the concerned police officer or the alleged perpetrator at the scene? Was it something that is a rule, whether it's written or not, or is it just practice that developed and became sort of the law out of just practice?
I would say that it was out of practice, ma'am, that it became the law. Because when I came to KZN, for instance, that is what they were doing. So I had to fall in what was happening in KwaZulu-Natal.
And would this bar only relate to the interview at the scene of crime, or would it go even beyond that you are not allowed or permitted at all to interview the alleged perpetrator?
No, ma'am, that would only happen at the crime scene. You would later then be allowed to speak to these people.
Thank you.
Chair, may I? May I proceed? Yes, proceed. Thank you very much,
Yes,
Chair. Then Ms. Williams, on page, at least on our side, 3-13, which is page 13 on your end, you have a section called the ICD investigation process. Could you just walk us through that?
Yes, Chairperson. In what follows, I distill the broad outline and timeline of an investigation conducted by ICD into a death caused by police action. I will refer to the ICD because the IPID was only established at the very end of my investigations into Cato Manor. However, as I have explained, in my experience, IPID investigations were substantially the same as ICD investigations. Whenever there was a death caused by police action, ICD investigators would conduct an investigation into the death and prepare a report. In broad terms, the ICD's investigation would unfold as follows. Whenever an incident occurred within the jurisdiction of the ICD, in this case, a death as a result of police action, the SAPS would alert the ICD immediately. In every case involving a death by police action, SAPS would assign the case number, a CAS number, case administration number, and open a docket. The ICD would assign the case a case console number and open a file. As soon as possible, the ICD would deploy an investigator to commence an investigation.
What will stand for CCN?
CCN is case control number.
In the 6 or 7 cases that you investigated, is any of those cases, including Berea, Commercial, Devon Central, I'm just speaking on the top of my head, is any of those cases given the CCN number?
All of them, Chairperson, is also given a CCN number. That is a different reference used by the ICD and also now the IPID.
At Council, because in all the dockets that I've seen, I've not seen anyone referred to as CCN.
Yes, Judge. No, we will. In fact, I think in the statement at paragraph 116, the individual CCN numbers for each of these dockets are set out by Ms. Williams, but we can come to that later.
Guide us there.
Yes. Thank you, Chair. Ms. Williams, you were still at paragraph 49.3.
Okay, I'm going to repeat 49.3. As soon as possible, the ICD would deploy an investigator to commence an investigation. In most cases, this meant that ICD investigators would immediately be sent to the scene of the incident so that he or she could conduct and prepare a report on the scene while the SAPS and the LCRC were still processing the scene. 2 ICD investigators were always, under normal circumstances, deployed to a scene together. The investigators would conduct an inspection of the scene and complete the pro forma ICD crime scene report, and the form is called the ICD 7/2. Within approximately 1 business day of the incident, the ICD allocation panel would determine which of the investigators would be the lead investigator in the case. I do not know what criteria the panel applied when assigning investigations. The lead investigator would conduct the investigation to completion. In most cases, the other ICD investigator, that would now be the second investigator, who attends the scene, is not involved in the investigation that followed. The second investigator could file a statement regarding the inspection that would be included in the ICD docket or the ICD file. This was not mandatory. On arrival at the scene, the ICD investigator would identify the SAPS duty officer and have a brief discussion on what had occurred. At this stage, the version of events conveyed to the ICD investigator would be the police member's version by the duty officer. The established practice was that the ICD investigators were not permitted to interview the police members involved in the incident at the scene. ICD investigators were able to interview the members at a later stage. I disagreed with this practice because there were no principled reason why ICD investigators should not be allowed to speak to the very persons they were investigating at the scene before they had an opportunity to get their stories straight. The inability of ICD investigators to talk to members on the scene was especially problematic when investigating the Cato Manor killings, because in those cases, the members' justification for the killings relied heavily on numerous members telling the same story. More generally, the expectation was that SAPS members on scene would provide the ICD investigator with full cooperation and assistance. The ICD investigator would be given access to the scene and would be able to investigate any non-SAPS witnesses on the scene. Once the investigator's assessment of the scene was complete, they would prepare an ICD crime scene report, Form ICD-7, setting out the location of the scene, the particulars of the deceased, SAPS members involved in the incident, and the identity of the shooters. After that, the lead ICD investigator would attend the post-mortem examination. While this was not a requirement in my investigations, I would usually insist that there be a site reconstruction involving the LCRC officers and ballistics. The nature of the ICD's investigation and its independence from the SAPS investigation that would follow these initial inquiries would depend on the investigator's assessment of the incident and whether, in his or her view, there was evidence indicating that the killing was justified or not. The default was for the ICD to conduct an investigation into the killing that was closely tethered to a parallel investigation by SAPS. In practice, the SAPS would open a docket and drive the investigation. The ICD investigator was not prevented from conducting his or her own inquiries, but the ICD investigation would rely on SAPS to take the lead and conduct the lion's share of the investigative work.
In practice,
I disagree.
Ms. Williams, in practice, will this not defeat the very purpose why these specialized bodies were created?
Exactly my point, Chairperson. This would defeat everything.
Just to follow up on that, I'm sorry, Chair.
You proceed.
Thank you. So you have an ICD investigation into an incident, and according to your statement, the SAPS was doing the lion's share of that investigative work. I mean, how does that come to be?
That would be now when SAPS would be taking over for full investigation. And that was most of the times that SAPS would be taking over the investigation and not ICD. Whereas, in my view, ICD should have actually taken over every investigation to ensure the independence and to make sure that there was no bias in those investigations.
Thank you. 49.13.2.
I disagreed with this and was frustrated by this practice. In my view, the ICD should never allow SAPS to investigate itself. This practice was especially problematic because, in my experience, SAPS tended to classify investigations into police killings as inquests instead of murder investigations. I suspected that this was to depress unfavorable statistics and because it seemed to be easier to justify closing an inquest than it was to close a murder investigation.
Sorry, Ms. Williams, if I could just interrupt you there. So you've told us that SAPS would be running its own investigation of the same incident. And now you're saying at paragraph 49.13.2 that these investigations were classified as inquests. So
That's correct, Chairperson.
my question then is, when then was a proper investigation ever done if an investigation is referred to an inquest?
They would still conduct an investigation, but obviously because it's not a murder, there were certain requirements that they didn't have to follow. And it was, for me, in my view, was it for stats purposes. And also, when they say that the shooting was justified, then obviously it becomes an inquest, and then they would not investigate as they would investigate a complete murder.
If the ICD takes a different view to a particular investigation that's been referred to an inquest, what becomes of that matter?
Just repeat your question.
So if the ICD running the same investigation as SAPS takes a different view to SAPS, who's, on the premise of my question, would have referred the matter to an inquest, what becomes of that particular matter? Does it move back from an inquest to somewhere else? What happens?
That was not something that normally happened in practice, but in the Cato Manor cases, the inquest was then converted into a murder, I believe, and that would have happened through the task teams.
Right. All right. And then,
Just come in.
I'm sorry.
Or are you following up on the...
No.
Ms. Williams, the matters that would reach, or the dockets that would reach the NPA, is it dockets where a recommendation would have been made, in particular by the ICD, that there should be prosecution? Or what is the position?
Yes, ma'am. After the completion of every investigation, murder investigation that we conducted, you would make recommendations to the DPP, whether you would recommend either murder or whatever else crime was committed in your view, and that would then be submitted to the DPP for decision.
Now, if the DPP does not, rather, I beg your pardon, if the NPA, we are talking about the NPA, if the NPA does not agree with a recommendation that prosecution follow, what are processes that would be undertaken by the NPA to communicate this, or rather the Director of Public Prosecutions?
What they would normally do, ma'am, is on the docket itself, in practice in the docket itself, with a letter attached that they would inform you that the matter would not be prosecuted and it was declined to prosecute, and that would be it.
Would they not furnish reasons as to why? Because maybe I take it that when you make a recommendation, you would motivate that recommendation for prosecution. Is that correct?
That's correct, Chairperson.
Now, if the Director of Public Prosecutions does not agree with you, you say they would make an inscription on the case docket that, well, your recommendation is not approved. But would that be sent with reasons for declining your recommendation for prosecution?
Not that I can remember. It would normally be null prosecute, decline to prosecute, and that was it. No reasons were furnished as far as I can recall.
Thank you.
Thank you. Ms. Williams, I'm sorry, Judge.
Let me verify with regard to the point made at paragraph 49.13.2, when the SAPS will then refer those matters for inquest. Will this happen after a full investigation, or will it happen at the stage when you would have completed the form?
That would be at the stage we completed the form. So what I mean in this, Chairperson, is that the SAPS would decide beforehand, before even conducting investigation and making proper inquiries, that this would be an inquest.
Now, pardon? Ordinarily, do members of the SAPS have such a power when the investigation is still ongoing to simply refer the matter for an inquest when the prosecutor is not involved as yet?
Ma'am, I didn't know that that could happen, but that is what they did in practice. They would open an inquest docket and they will investigate it as such, as an inquest. In my experience, you investigate murder, and then only after a prosecutor has seen that docket, then it would be converted into an inquest. But unfortunately, that was not practice that was used.
And you state that the members of the SAPS preferred that route because it seemed easier to justify closing an inquest than to then refer the matter for full investigation.
That's correct, ma'am, as well as for statistic purposes.
Thank you.
Yes, Chair. We do want to point Ms. Williams to a document in the dockets. She does have the dockets with her to answer the chairperson's question. But I'm mindful it's now almost 2 o'clock. And before my neck is wrung for lunch, I wanted a directive from the chair.
You read my mind. Miss Williams,
Yes, Chairperson.
we normally take a lunch break at 1:30. It is now 2 o'clock. We propose to take a 1 hour lunch break. I hope that will suit you.
Yes, Chairperson. Only one request.
Yes, ma'am.
The matter that was referred to just now, if I could just be told which matter it is so that I can just prepare for when we start. By the evidence leader.
Yeah, Ms. Williams, it would be the Guatuguza docket, but we'll point you to the specific page.
Okay, thank you, sir.
Thank you.
Thank you, Chairperson.
Thank you, madam. We are going to pause for lunch break until 3 o'clock, and we will resume at 3 o'clock. Remember, you are under oath, and when you are on that stand, you don't discuss the case with anybody.
Correct. I understand, Chairperson.
Understood?
Yes, Chairperson.
Yes, thank you. We will adjourn for lunch and reconvene at 3 o'clock. We adjourn. Good afternoon, everyone, and good afternoon, Abubakar Chake. Thank you, sir. Good afternoon, Madam. Ms.
Good afternoon,
Williams.
Chairperson.
Good afternoon.
Yes, Chairperson. Good afternoon, ma'am.
Yes, thank you. Remember, you are still under oath.
I'm aware of that, Chairperson.
Thank you. You may proceed, Counsel.
Thank you, Chair. Ms. Williams, we were still dealing with paragraph 49.13.2 of your statement, in which you say that, in your view, the ICD should never allow SAPS to investigate itself, but the practice was that SAPS would classify investigations into police killings as inquests. And the chairperson asked you whether the police had the power to refer matters to an inquest, and I said that I would give an example to demonstrate that. Do you, by any chance, have the... I think we've lost Ms. Williams, have we?
No.
Oh, there she is. Do you, Ms. Williams, by any chance, have the Kwatuguza docket with you? Kwatuguza 39-08-2008, I think.
Yes, I do. Just give us one moment.
Sure.
Yes, I do have that, Chairperson.
You will note, Ms. Williams, that there is numbering that appears at the top right corner of the documents in that file. They all begin with KD. Do you see that?
I see that, yes.
That's the generic numbering, and when we go through the other dockets, you'll see that as well. If I could ask you to turn to KD 0005.
Okay, I'm just looking at my numbering on here, Chairperson. Chairperson, there just seems to be a problem. I see the KD numbering here, but on the stuff that I have, there is no index on there. So if the evidence leader can just point out which document he's referring to.
What we'll do, Ms. Williams, I apologize for that, is we'll put it up on the screen as well, so that you could be able to read it with us. It's KD 0005. Do you see that?
Yes, I do.
Could you tell the panel what document it is that we're looking at?
That would be the preamble.
No,
That is used.
it begins at the top of the page, South African Police Service, and then it says statement underneath the police badge.
Yes, I see that. It refers to the particulars of an incident where that is described.
That's right, yes. So what is this document that we're looking at?
This is a preamble that the police use when a docket is registered. That's a preamble.
So this document is called a preamble.
Yes.
And could you read what's indicated there as the date of the... Sorry, before that, it says station. What's the station that appears there?
The station would be Kwadukuza,
And the CAS number?
39 of 9, 2008.
And then on the left-hand corner of that document, it says date and time of offense. Can you just tell us what that is?
It's 2008, 09, 03, and the time would be 10 past 12 in the morning, a.m.
Right. And then you have there, it says description of offense. What's the inscription we see there?
Inquest.
And then under method used,
Shot at with firearms.
and then the type of instrument used,
It will be a firearm used, Chairperson.
And then there's a column there that says scene of the crime. Can you just tell us what it says there?
It says 59 Rose Road, Stanger Manor in Stanger.
And then there's a date at the foot of that page. What's the date that appears there?
It's dated 2008, 09, 03.
So this document that we're looking at, Ms. Williams, would this be the kind of referral that you were referring to in paragraph 49.13.2?
That's correct, Chairperson.
Now, if I could just ask you, what's particularly peculiar about this document is that it says that the date of the offense is the 3rd of September 2008, and then it says description of offense, and then it says inquest, and then there's a date at the foot there, 3rd of September 2008. Why is that?
In practice, this should not be. With the description of the offences, that should have been murder right from the onset. But as I have explained, the reasons that SAPS used, and that is the problem that I had, because I felt that ICD should have pushed for separate investigation and then also to ensure that a murder docket is opened, and that was not always what happened in practice.
So is our reading correct here that the date of the incident and the date of this referral are the same?
That's correct, yes. That's the date the decision was made to open this as an inquest.
So then at what point is a proper investigation then done if it's referred to an inquest on the same day of the offense?
There is no time here. So I would think this would be a premature decision.
So then, Ms. Williams, then I go back to what you said in paragraph 49.13.2, where you say it was practice for SAPS to classify killings by police as inquests. And with this document that we've looked at, can you just tell the panel why that is so?
Will I just tell the panel?
Why that is so? Why is it that when you say it was often practice for these killings to be referred to inquests, and we've now seen an example of that here in Kwatukuza, why that happened often in practice, in your words here in the statement?
This practice was especially problematic because of my experience. SAPS tended to classify investigations into police killings as inquest instead of murder investigations. I suspected that this was to depress unfavorable statistics, and because it seemed to be easier to justify inquest than it was to close a murder investigation.
So let's spend a little bit more time on that. When a matter is referred to an inquest, is there an investigation that's happening at the same time?
Okay, there's two different train of thoughts here. If you have a murder investigation, you conduct a full investigation, you then send the docket to the DPP. The DPP would then say not prosecute, and then afterwards, then obviously you will then prepare an inquest for court. But in this instance, before that even takes place, the decision is made prematurely, as far as I'm concerned, and an inquest is opened, whereas it should have been the other way around, because a murder then results in an inquest, but not an inquest to a murder. That is not standard practice that I am aware of.
And outside of Kwatukuza, did you come across any similar examples, such as the one we've just looked at now?
There was numerous examples of that. And unfortunately, I do not have all the stats for you at the present moment, but there was a whole lot of matters that I especially fought with the police for.
Advocate Ramokhali, may I just take you one step back so that I don't lose the questions that I wanted to ask. Ms. Williams, you have indicated that, in actual fact, what I'd like to get is the distinction on how the dockets are processed. The one where the report reflects murder as against the one where the report reflects inquest. Now, you have placed on record that if it is indicated on the docket as a murder, it would then be investigated, and then a report would then be sent to the DPP with a recommendation, be it for prosecution or for non-prosecution. Now, the docket that is marked as inquest from the beginning, how is it processed moving forward?
I hear what you are saying. An inquest is then investigated, and then that docket is then formal inquest. It will just be processed by the prosecutor dealing with that matter.
Yeah, we lost you at some point. You had frozen. Will you please repeat your answer to the question?
Not a problem, Chairperson. What I was saying is that when that inquest is opened, an investigation follows that, and then when that matter is then closed, then obviously that matter will then be prepared for the inquest court. It will go through a prosecutor who will read, and at some instances, the prosecutor will then also then refer to a formal inquest, but in most instances, the matter is read and then it's signed off.
Okay, thank you.
So just so we understand your answer, you're saying when the matter is referred to an inquest, an investigation also continues at the same time?
That's great, because it's still considered a docket and it's still considered an investigation, but it's just that the charge is different.
I understand. Now, one of the things that's strange about that Kwatuguza document is how is it that it was known just on the same day of the incident that the matter must go to an inquest?
That baffles me because, like I've said, the decision to have it registered as an inquest was premature. That's in my opinion.
And then just tell us, ordinarily, when a shooting incident happens involving the police and a docket is opened, at what stage in normal practice could you say this is out of order? Is a decision to refer to an inquest made in the ordinary sense?
Okay. In the ordinary sense, what you would do, you would conduct an investigation. You would first establish all the facts and make sure that there is nothing out of the ordinary or there is no foul play. Only then, I think you can consider it to be an inquest. But my opinion still will be, as it has been, my stance has been when I was at ICD/IPAD, is why not investigate as a murder, which is standard practice that I know, unless the law has changed, which I don't know, or maybe I was not aware of any changes in the law. And then afterwards, after submitting the docket to the DPP or to the SPP, wherever it's going to go to, but in our case, it mostly was the Director of Public Prosecutions, only then a decision could then be made for this matter to be an inquest.
And Ms. Williams, is there a difference between the kind of investigation done when a matter is referred to an inquest and the kind of investigation done when it's referred to as a murder investigation?
In my opinion, it should have been the same. But obviously now you are investigating differently. So I don't think that the person investigating the inquest will be as thorough as they would have been when they were investigating a murder charge.
And why is that?
Because the elements would be different. The elements of the crime would be different.
Ms. Williams, let us maybe just trying to understand and compare on the understandings that all people are equal and they are treated equally so. Your background is that you started off with the SAPS, the South African Police Service. You joined it in 1991 as a student constable. And are you able to tell us as to what the approach or normal approach would be in a case where a person has been killed by a civilian? Are there cases where right from the onset, the very day that there is a report that so and so has killed so and so or someone, that such a docket would then immediately be marked as an inquest. If that is not the case, just explain to us as to what normally happens in cases where the killing would have been caused by an ordinary civilian.
Chairperson, as far as I knew when I was back in the South African Police Service, every murder that was committed or any act of where a person was killed was back in the day, it was investigated as a murder. And then only after the murder the investigation was finished and the docket was submitted either to the SPP or the DPP in some instances. Only then a decision was made. Yet, when I got to ICD, the practice and what I saw in KwaZulu-Natal, the practice was different.
Was it different in respect of even the civilians, or was it peculiarly to a certain group of persons or a certain category of persons? Thank you.
Ma'am, I will not be able to explain to you where the civilians are concerned because by this time now I was investigating the police. So I don't know what changed or why the police were then treated differently to what normal civilians that I knew of, the matters that I knew of was treated differently. That I will not be able to explain to you.
Thank you, Ms. Williams.
You're welcome, Chairperson.
So is it your testimony that killings that were committed by police that resulted in death were treated differently to those killings committed by ordinary civilians?
In my opinion, yes, Chairperson.
Thank you, Ms. Williams. We then move to...
Before that, Council, sorry.
Sorry, Chair.
The KD 0005. Council referred to the description of the offense on that page, and the offense is written inquest.
Correct, Chairperson.
Is that a mistake?
Ma'am, this was not a mistake. This was a decision that was clearly taken at the scene.
No, but when you look at the form says description of offense, incident.
Oh, I understand what you mean.
Cannot be an offense.
Yes, this is not an offense, ma'am. This is an inquest. There should have been something else, and in my opinion, this should have been registered as a murder.
Yes, because the next part reads method used, and
Yes,
it's written shot at with firearms.
correct, Chairperson.
Would you know this, who signed this document?
I would not know that, ma'am. I was not privy to what happened at that scene or who was actually the person that was responsible for opening the matter.
I earlier on asked you about the CCN number that you allocate to the cases that you investigate.
Yes, ma'am.
I'm looking at the same document, KD 0019. If you page through that.
And what would that document be?
Of the same document, sir. KD 0019.
I do not have the KD numbers indexed on my documentation.
There it is on the screen. Look at the screen.
Yes, ma'am, I see that. I'm just trying to find that quickly. I apologize for this. Our numbering is not the same as yours.
Oh, okay. But you can look at the screen. The part that I'm referring to is right in front of you on the screen.
Yes, ma'am. I'd rather prefer to use that way because it will be better. Yes, ma'am, that is the crime
Which one
scene.
do you prefer to use, the screen or your document?
I will use the screen for now, and then just later tonight, I will make sure that we have everything documented correctly.
Yes. That document on the screen is supposedly the ICD report, correct?
Yes, ma'am. It's in the-
And it bears that CCN number.
Yes, ma'am.
Will this matter be the same as the matter referred to at KD 0005, case number 39/09 of 2008 that we earlier on looked at, Kwatukuza?
Yes, Chairperson, it is the same matter.
Now look at the report date on your ICD report. When I mean your, I'm not meaning you personally, but your office.
Yes, ma'am.
The date
I'm-
there is the 4th of September 2008.
Correct, Chairperson?
And the incident, as you would have seen from the case number that we looked at earlier, is the 3rd of September 2008.
Correct, Chairperson?
And the complainant is ICD,
That's also correct, Chairperson?
reporting staff member P. Dlamini.
Correct, Chairperson?
The assignment, investigations.
Yes.
You see that?
Yes, Chairperson, I see that.
Now, as per your report, the matter was still under investigation. Am I correct?
At this stage, it was under investigation, yes, Chairperson?
That is as at the 4th of September 2008.
Yes, Chairperson.
But before that, whilst you were investigating, the matter was referred to inquest already by the police.
Correct, Chairperson.
What do you make of that?
Ma'am, the only thing I can say in response of that is there was a clear dereliction of duty.
If you look at the next page, yes, sir, you can turn to KD 0020. It reads there under section 4, the suspect. The only witness did not witness the actual shooting. You see that?
Yes, I see that, Chairperson.
And it's written Branch Commander Kwadukuza SAPS.
I see that, Chairperson.
Thereunder, you have the words the investigating officer, meaning the investigating officer is the Kwadukuza SAPS. Am I correct?
That's correct, Chairperson.
Whereas on the page that we dealt with before, investigation is by ICD.
Yes, ma'am. If you would like me to explain why that is so.
Yes, please do.
Okay, when you go to the previous page 19, KD 19, what this means, that the Independent Complaints Directorate had decided that the matter would be allocated to Ms. P. Dlamini. And Ms. P. Dlamini was then the one that was supposed to conduct an investigation to establish whether or not the shooting into this matter was justified or not. The SAPs would then still have their own investigator, which they had at that stage, that would conduct the investigation into this matter.
Yeah, are you done?
Yes, ma'am, I'm done, Chairperson.
This ICD report then makes nonsense of the earlier document that refers the matter for an inquest at KD 00005.
Yes, ma'am.
Yes, thank you.
Thank you, Chair. In fact, Ms. Williams, we will put on the screen yet another document in answer to the Chair's question about how these referral processes work. If we could get the docket from Komas.
Sorry, before you proceed,
Yes, yes, see.
maybe Ms. Williams can clarify, because I know I asked this question when one witness was testifying. If you to the first page, summary of complaint. Oh, yeah, summary of complaint. The last but one sentence. It says he was then shot by Inspector Mostert and he died at the scene. Suspect was
Yes.
identified as Lindelani Buthelezi. Isn't this clear that the the suspect was shot by a police officer, was shot and killed by a police officer?
Yes, ma'am, it is crystal clear, Chairperson.
Now, if you go to the next page where the chairperson referred you to just above the branch commander, Kwadukuza, SAPS, we have these words that says the only witness did not witness the actual shooting. Do you care to explain or give your view on that, especially read with what I've just read on the previous page?
Yes, Chairperson, I understand what you are asking. I'm going to give you my view. And it's a bit difficult to explain because I was not the one that did this. But the person in question here should have given a more detailed explanation. And what is written here does not make sense to me, that the only witness that witnessed the actual shooting. The person should have elaborated on why they said this, because it does not make sense at all.
In fact, Ms. Williams, does it not go further? If on the same page, under section 6, it reads, can you see that on the screen?
Yes, I actually have the actual
Oh, you have it
document
now. Wonderful.
in front of me, yes.
Yes, it says time required to complete the investigation, and it says investigation is complete. And it says planned investigative activity during period, and it says final report. And then we turn to the next page, KD 0021, and then it says closed unsubstantiated, and there's a signature there with the name provincial head, and a date that appears 3rd March 2009. And then the next page, section 7, and it says investigative conclusions, and in brackets it reads, this portion of the report shall contain the investigator's conclusions with respect to each individual alleged offence and or acts of misconduct. This section shall only be completed for final reports. And then under description of allegation, death as a result of police action, investigator's conclusion, unsubstantiated, the SAPS members acted accordingly. And then we see a name with a signature and some comments. What I wanted to ask you about is, if we turn a few pages back at KD 019,
I have that, yes.
Can you just tell us what is the date of the incident and what is the date of this report?
The date of the incident is the 3rd of September 2008.
And the date of the report?
The date of the report is 4 September 2008.
Now, a witness was asked about this, and I'll ask you for your comment as well. How is it that the ICD, as of the next day after the incident, is able to conclude that the allegations are unfounded and the SAPS acted accordingly?
The only way for me to respond to that is that no investigation was conducted and it is a clear dereliction of duty because there was not enough information, in my view, that would have made this investigator conclude or come to this decision.
Thank you, Ms. Williams. Chair, if I may.
Yes, on the last page of that document, KD 0021, just to make a follow-up on what Council is asking you. There's a date there, 2009, March 30th.
I see that, Chairperson.
What does this date signify?
It says 30 March 2009.
Yes. Who puts that date?
The date was placed here, I see, by the acting provincial head at that stage, Mr. Nene, Sipho Nene.
And the provincial head read the report of Ms. Dlamini.
Correct, Chairperson?
Which shows a dereliction of duty, as you said.
Yes, ma'am, that is crystal clear.
Before we proceed, can Ms. Williams just briefly tell us? I know you said there are certain preliminary information that you gather when you get to a crime scene, like the name of the deceased, the shootist, if you know the location. But other than that, is there other steps in the investigation that needs to be taken for us to want to come to a conclusion that this investigation was finalized prematurely, and not necessarily because the end result would point us at a murder, whichever way, but are there other steps that needs to be taken in finalizing the investigation?
In my view, yes, ma'am, and it's what I did with my investigations. You would choose witnesses and you would interview them. You would gather all the information. In addition to that, you attend a post-mortem. You also engage ballistics. In most of the cases that I have investigated, and that will also be evident later on in my testimony, I would always ask for a reconstruction. And those are the things that would actually guide you into which direction the investigation should go. So if you do not have all that information prior to this, in my view, you are not able to make an informed decision or a correct decision, whether the file should be finalized or whatsoever, because you do not have all the relevant information at this stage. It's too soon.
And not only that, the prosecution had not been approached at that time.
No, Chairperson, it has not been approached.
Proceed, Council.
Thank you very much, Chair. Ms. Williams, let's continue on now from paragraph 49.13.3 of your statement.
Just 1 second. 49.
49.13.3. It
In
begins
other
with,
cases,
yes, that's right.
Yes, Chairperson, I have that. In other cases, a decision would be taken early in an investigation and the ICD should conduct a full investigation into the matter. The ICD would effectively take over the investigation from SAPS and would conduct a comprehensive investigation independently from SAPS. There was no hard and fast rule as to when a matter would or would not be referred to as full investigation, but it would generally be triggered by compelling evidence that the police action was not justified. Again, in my view, there should not have been investigations by the ICD that were not taken for full investigations. If the ICD decided to conduct a full investigation into the case, it assigned the case number, opened the file and maintained a separate ICD docket. An investigation diary recording all of the steps taken by the ICD investigator in the matter would be maintained. The investigation diary provides a chronological blow-by-blow record of the steps taken by the investigators. This includes the taking of witness statements, the collection of physical evidence, and the submission of evidence for ballistic or other tests. In general, if there are gaps in investigation, they will be apparent from the investigation diary, read together with the documents, including in the A clip and the B clip of the docket. If the ICD decided to conduct a full investigation, it would take over the SAPS docket, effectively converting the SAPS docket into an ICD docket. Every ICD investigation, regardless of whether it was a full investigation or a collaborative investigation with SAPS, would be finalized once the investigating officer had formed a view on whether the police action was justified. When the ICD conducted a full investigation, a memorandum would be submitted to the DPP, regardless of whether ICD had concluded that the police action was justified.
Thank you, Ms. Williams. We now begin your evidence with getting into how you got involved in the Cato Manor investigations, in particular what you had found in the course of your investigation. In paragraph 51 of your statement, you informed the panel that there were 3 phases. Could you tell us about what those 3 phases are?
The first phase would read as such, Chairperson. The first phase took place when the ICD conducted its initial investigation into each incident. In 3 of the dockets mentioned above, I was the lead investigator in this initial phase. For some of the cases, there was a second phase of investigation that began when I obtained authorization from the ICD to reopen ICD investigations into the KTA killings. My re-investigation began in November 2009 and continued until around August 2011. I described these re-investigations and their outcome below. A further investigative phase began after the publication of the Sunday Times expose on 11 December 2011 concerning alleged unlawful shootings by members of the Cato Manor SVC, which then led the then national head of the Director for Priority Crimes Investigations, DPCI, Lieutenant General Anwar Dramat, to establish a specialized task team under the command of Major General NJ Mabula to investigate allegations. I was not a member of the IPIT task team that was formed in early December 2011 and was involved in or privy to its investigations into these matters.
Thank you, Ms. Williams. You then set out more information from paragraph 52 all the way down to 59. We'll come back to that a little later. Instead, I'd like you to now move on to paragraph 60 of your statement.
Paragraph 60 reads as follows, Chairperson. Shortly after my transfer to the ICD office in Durban, I was warned about a controversial police unit in KwaZulu-Natal that had a history of shooting and killing suspects when effecting arrest. The unit was the Cato Manor Serious and Violent Crimes Unit, headed by General Johan Boyson. As far as I can recall...
Ms. Williams, I'm sorry to interrupt you. If I could ask you just in paragraph 60, you state there that you were warned about a controversial police unit. Who were you warned by?
I was warned by a former colleague of mine, Benedict Nanana.
And what?
He effectively just told me when I came there, he said, spoke to me, Ms. Williams, there is this unit that you are going to encounter. Just know that this is what they are doing, and he described that when they are effecting arrest, people normally ended up dead. He also told me that it would be difficult for anyone, because they were battling with this unit, for you to actually ever have a prosecution against them, because these members, they close ranks and they tamper with scenes, but it was difficult for ICD at that stage to actually get the evidence for successful prosecution against these members.
And do you recall when you had that conversation?
That would have been sometime in 2007, just shortly after I arrived in KZN. I arrived in KZN, I think, in August of 2007. So this would have been, I think, in September of that year.
So a few weeks later?
Yes, Chairperson.
Yes, and at paragraph 61?
As far as I can recall, my first encounter with the Cato Manor SVC occurred when I arrived at the scene of a shooting in Malvern, Durban, shortly after my transfer to the ICD Durban office in 2007. When I arrived on the scene, I was informed that the members of the Cato Manor SVC had shot and killed the deceased, allegedly in self-defense after the deceased fired shots at officers. This case was not one of the 23 cases included in the 2012 indictment against Cato Manor, and I was not the lead investigator in the matter.
Thanks, Ms. Williams. Just to let you know, we do have a witness who will speak to this particular Malvern shooting, but if you could continue at paragraph 62.
Following this, I was involved in several cases investigation into killings by the members of the Cato Manor SVC of the 23 dockets that formed the subject of the NPA's prosecution in 2012. I was the lead investigator in Berea case 288 of 5/2008, Durban Central case 185 of 2/2009, and Kwamashu case 698 of 11/2009. I attended the scene but was not the lead investigator in Durban North case 67 of 7/2011, Durban North case 71 of 7/2011, and Durban North case 69 of 7/2011, as well as Pinetown case 1000 of 5/2009. I reopened the ICD's investigation and was the lead investigator in Kwadakuza case 39 of 9/2008, Howie case 106 of 9/2008, as well as Mandini case 76 of 9/2009, and Umkoma's case 235 of 10/2008.
Thank you, Ms. Williams. Then at 63, you speak to the Umlazi matter, which we'll come to later. We then begin at paragraph 64 on page 3-22 of your statement into Berea CAS 288-05-2008, and then brackets there, it's Tabo Sunshine Msimang. Can you just tell the panel in your own words about this particular matter?
On May 24 May 2008, I attended this matter. It was a shooting in the Greywood area in Durban. Arrived on the scene. I remember clearly seeing this gentleman, a black man, that was lying in the parking area of the flat. I was then approached by the duty officer. The duty officer informed me what had transpired, saying that this was a suspect that was sought by the Cato Manor SPC, and that the suspect was in the flat that was on the 4th floor. According to the police officer, the duty officer that was giving this information to me, the suspect had, when the police tried to enter the flat that he was in, had shot at the police, and the police returned fire. The suspect then jumped out of the flat, fell on the ground, and was shot again by police officers that was at the bottom of the premises.
And then you tell us in paragraph 69 that the members of the Cato Manor SVC forced their entry to Mr. Msimang's flat late at night using a crowbar. This is what they did when they killed the suspect in the 2009 Melvin case I mentioned above. What do you mean by that? Can you just tell us more?
For me, this was the same manner in which they had gained entry at the Melvin place. A crowbar, if I can explain what happened at the Melvin premises. Upon arrival, we noticed what was happening at the scene. I then spoke to the deceased fiancée, and I asked her what had happened, what she had heard, because she was in the house when this happened. And she had related to me, chairperson, that they were asleep and they heard somebody breaking in to the house. She related to me that the then deceased went out to investigate what had happened, and encountered the people. They approached him and he had surrendered. And then afterwards, when we checked the door and I spoke to the duty officer told me that the crowbar was used to gain entry into the premises, and that the alarm and telephone cords were also, what is the word? They had used something to make sure that that was not working.
Make sure that it was not working.
Ms. Williams, can you hear that?
To cut the telephone lines as well as the alarm lines. But the point that I'm trying to make, they used the crowbar, and in the same method in the Berea case, they also used the crowbar to gain entry into the premises.
The Alvin case, we are told here that it is not part of the 23 cases against the Cato Manor team. And you said earlier that you'll revert back to the Melvin case. Is this case, the Melvin case, Durban, has it been before us in the form of a docket?
No, Chairperson, it hasn't.
It hasn't.
What the panel has seen of the Melvin case are the two videos that we played last year, at the end of last year. These were the videos that were taken by Mr. Ari Danikas, who you recall, we had said we'll call him, but in his statement he speaks about this particular Melvin case and why it is of relevance to the way in which the K2 minor unit operated.
Yes, thank you.
Thank you, Chair.
Chairperson, if I may interrupt.
You may, ma'am.
I think there is a bit of confusion when it comes to the Malvern case. There are two Malvern cases, if I can just bring your attention to that. The Malvern case, I know that Iris Danikas is referring to, is not the same Malvern case that is mentioned here. I just don't want there to be any confusion with the inquiry. It just has to be established because I am aware that the matter that I am referring to was investigated by Ms. Maza Mpanza. And Iris Danikas had already left before that. I know that I can't remember where I got that information from, but the Malvern case that he referred to happened prior to this one. This one happened after I got to KZN.
This one is the 2007.
Yes, ma'am. I believe it's the same year, but it's two different incidents.
Would you have the case numbers for this Malvern case, Durban?
I do not have the case number, but what I can do, ma'am, with your permission, is I can call, when we are done here with the proceedings, I can ask Mr. Len John, who's the Deputy Provincial Head of the IPID, to see if he can check in the registers for 2007 to check for the Malvern case that myself and Ms. Mpanza attended. And then I can provide you with a CCN number as well as a case number for that matter.
Advocate Ramkhale, that is important so that we distinguish the two cases.
Indeed, Chair.
It may well be that the one that Mr. Danikas is referring to, in respect of which you showed us the pictures last year, may be different from this Malvern case that she's referring to. So if you can just pin your finger to it and then await the information that she's going to find out and then give us the case number, this Malvern case, Durban, the case number, then we can differentiate it from the other Malvern case.
Thank you, Chair. Indeed. We'll attend to that. Chair, it's 4:01. The bits that I need to cover will take up quite a bit of time. I'm not sure whether we're going to run until 5 o'clock or if this is the time that we'll be adjourning for the day.
I'm not used to speaking to these things. We will then take an adjournment and adjourn tomorrow at 9 o'clock. We will then continue with that law matter that you're about to start with.
Indeed, Chair. As a panel, please.
Ms. Williams?
Yes, Chairperson.
I think that this might have been a very long day for you. We are going to pause and we'll request that you present yourself at that venue tomorrow again. Will that be possible?
Yes, Chairperson, it is possible.
We are going to start at 9 o'clock tomorrow. And
Yes,
we'll
Chairperson.
appreciate if you can be seated at the venue at 9 o'clock tomorrow.
That is possible, Chairperson.
And remember that you adjourn, still being under oath, until tomorrow.
Yes. Thank you, Chairperson.
Council, to all council, we will adjourn until tomorrow morning at 9 o'clock. We adjourn.